Your Lordship's kind leave, my lord, and today to mention this matter. This is, my lord, my witness has been examined in chief, undefended suit, but then the defendant has a right of cross-examination. Today is fixed at 2 p.m. for cross-examination of the defendant's, of the plaintiff's witness, my witness. I'm told, my lord, there is, because of the situation, my lord, he's trying his best, but then there is a chance, high chance that possibly he may not be able to reach court. So I was only requesting, my lord, that...
Okay, let if not come at 2. If not come,
my junior would be there, my lord, in that event. There's a GA filed by the defendant, my lord. We'd like to use an affidavit in that GA. Grateful, my lord.
My lord, may I take a leave to mention, my lord, this matter? My lord, this matter is fixed for examination of witness tomorrow, my lord. In this matter, Deepnath Roy Chaudhary is appearing, my lord. Deepnath Roy Chaudhary is appearing, my lord, and his father has demised, my lord, on the just Friday, my lord. So kindly keep after the 2 weeks, my lord.
22nd July. Tomorrow.
My lord.
Tomorrow at 10. Who is for the other side?
Lordship, I appear on behalf of the defendant number 2.
No, my lord. That is another matter, my lord. Similar party, there is 2 matter, my lord. We are mentioning upon notice, my lord. They are probably
not. Who is appearing?
He's a Hemant Tiwari, my lord. We have served the notice, my lord. But probably due to this situation, he may have not.
Okay. Isko note karke rakho. But the other side is not there. Mentioned tomorrow. I will see.
My lord, there is a similar one other matter, my lord. It is fixed on the 24th, my lord. And my learned friend is appearing, my lord.
I appear on behalf of defendant number 2 in this matter, Your Lordship.
On 24th, my lord.
The matter is mentioned by the learned counsel for the plaintiff and submit after notice to the defendant. Counsel for the plaintiff submit that the court, by an order dated 5th May 2025, has fixed the matter on 24th of July 2025 at 2 p.m. for witness action. But due to some unavoidable circumstances, the counsel for the plaintiff is not in a position to conduct the case on the said date and accordingly prays for adjournment. Counsel for the defendant also not raise any objection. Accordingly, hearing of the case on 24th of July 2025 is adjourned. Let the matter up, give the date for September at 2 p.m.
I have your kind leave to mention, Your Lordship. Item number 9 of today's list, Your Lordship, it is fixed for the plaintiff's witness action. Lord, I am appearing for the defendant. I have filed, my lord, 2 GA applications. Lord, one for recalling of the order and one for
item number
condonation of delay. Item number 9, my lord, I am served notice upon the other side.
9 at 3 p.m.
Yes, my lord, I am praying for an adjournment of
come at 3 p.m. Come at 3 p.m.
2 applications I have filed.
Come at 3 p.m.
3 p.m.
My lord, may I be permitted to mention a matter? My lord, if your lordship takes this last order, my lord, the matter is fixed tomorrow. Witness action of the plaintiff's witness have concluded. It is for commencement of the defendant's witness action, my lord. I have been told, my lord, on instructions, my lord, the defendant's witness is suffering from a respiratory disease. My lord,
the defendant?
My lord, we have given notice, my lord. This is the notice. My lord, just because it was fixed, my lord, I thought it necessary to mention it whenever I got to know that he may not be available tomorrow for commencement of the witness action, my lord.
No, the defendant has to say.
Yes, I am for the defendant.
For the
yes,
defendant.
my lord, I am for the defendant. My witness has to be in the box and it has to commence tomorrow, my lord. My lord, may I say this, my lord? May it be fixed tomorrow, my lord? May it be kept tomorrow? The parties will be there before your lordship, my lord. Whatever orders has to
note, Carlos.
Mr. Thakkar was to mention the matter.
May I have my lord's kind leave to mention a matter on the virtual mode, please, my lord. Your lordship has been, your lordship remembers that Piramal matter which was argued the other day, my lord. Money versus Piramal. Your lordship has been pleased to fix it tomorrow at 10:30. But tomorrow, I'm told, my lord, there's a swearing-in ceremony, my lord, so the matter will not be perhaps taken up at 10. Can it be fixed at 11:45, please? I am for the respondent, but I want the matter to...
Let it be taken at
11:45, if your lordship kindly fixes it.
11:45 क्या है? 11:30 mixed fixed matter.
Okay,
not 2 p.m.
2 p.m. 2 p.m. This my senior will be in some difficulty. If your lordship kindly will take about. Can it be on
3 p.m.
In the second half, he has some fixed matter, my lord. I'm requesting
because 11:30 onwards, my other fixed matters are there.
I see. Then, my lord, can it be on Can it be on Thursday, please, my lord? May I beseech your lordship? my lord?
Thursday, my lord, I'll have to take instruction, my lord, Mr. Shah, Mr. Banerjee, my lord, all are there. My lord, may it be there, my lord, as item 1 tomorrow, my lord.
Yes, tomorrow then we can come and beseech your
It will
lordship.
be there, but 11:45 the court will sit and take seat, and 11:45 will take the fixed matter. I will not take the other matter. Fixed matter has to be taken, so this 10:30 matter cannot be taken up for hearing.
Beseech your lordship to fix a time tomorrow, my lord. After
So,
that, we can find out Mr. Shah's convenience, my lord.
Thursday 2 p.m.
Yes, my lord.
Thursday 2 p.m. Check.
Kindly give me a minute, my lord. Thursday morning, your lordship, it is not convenient, my lord.
Morning, I don't think. Morning or matters are fixed.
Then, my lord, keep it at 2 p.m. on Thursday, please, my lord.
उसको ना खाली रखो. कल जो मैटर है ये थर्सडे का उसको खाली रखो मार्क करके किसी को देना नहीं. कल जब मैटर फिक्स होगा then I'll fix the matter. I am not passing any order. Let the matter come
Yes.
tomorrow, then I'll
Please,
fix.
I'm so grateful, my lord. Deeply obliged, my lord. So good.
Yes.
My lord, on the scrutiny, my lord, one defect is my lord, reported, my lord, in the statement of truth, page 6, my lord. My lord, mistake in the statement of truth, my lord, page 4, paragraph 6.
Yes.
It should be, my lord, 23 instead of 6. There are 23 pages.
Above mentioned pleadings comprises of
23 pages. But wrongly the type is 6 pages.
for this it is mentioned here.
Since affirmed, leave has to be taken from your lordship.
The matter is listed as to be mentioned. On receipt of the report from the section officer attached to the office of the London Master and Official Referee, dated 15th July 2025. Full stop. In the report, it is mentioned that in the statement of truth filed by the plaintiff at page number 4, paragraph 6, the number of pages is wrongly mentioned as 6 pages. 6 pages convert ko. Yeah, 6 pages instead of
23 pages.
23 pages. 23 pages. Counsel for the plaintiff prays for leave to correct the page number as inward comma 23 pages instead of 6 pages in page 4, paragraph 6 of the written statement of truth. Consider the submission made by the counsel for the plaintiff and the report submitted by the section officer, comma, the plaintiff is granted given leave to correct the page number as page number as 23 pages instead of 6 pages in statement of truth at page number 4, paragraph 6 by
Today, my lord, if the record goes down, I will do it tomorrow, my lord.
by Tuesday. By Tuesday. Let the record be sent to the department for taking appropriate step by the
My lord, I am grateful to lord.
by the plaintiff. I wait this.
Lord, I am for the plaintiff respondent in GA3 and GA4. These are two GA applications filed by the defendant seeking for revocation of the leave under
You are
clause
for the
12.
defendant?
I am for the plaintiff, my lord.
Yes.
I am for the plaintiff, my lord. Two applications filed by the defendant. Pleadings are completed. The applications are for revocation of leave granted under clause 12 and rejection of plaint.
Okay.
Two separate applications. I don't know.
So pleadings completed.
Pleadings are completed, my lord. Your lordship, on the last occasion, if your lordship takes the last order, the defendant had sought for time and your lordship had adjourned it to today for hearing. It may be kept any day.
What about the affidavits, exchange of affidavit and Discovery and inspection.
Discovery inspection we have offered even after the last day, my lord. They have not taken till date. Your lordship has kept the suit in August, my lord. I think 2nd of August. On that day, I'll ask for further orders in that, my lord. That today I will.
Learned counsel for the plaintiff is present. None appears on behalf of the defendant. It is submitted that pleadings in connection with GACOM 3 and GACOM 4 of 2025 is completed and matter is ready for hearing. In view of the above, the case is adjourned. For the interest of justice, the case is adjourned. Let the matter appear. कोई डेट है क्या? अच्छा ये तो कमर्शियल है ना? When?
But whenever.
Matter appear on 7th August. 7th August for as adjourned motion.
But I appear for the defendant respondent.
Yes.
Defendant respondent, my lord, the plaintiff has taken out an application for an amendment of plaint. Pursuant to my lord's last order, perhaps my lord, a report was, my lord, will kindly have my lord's last order.
Counsel for the plaintiff they have prepared.
They've served a copy on us, on my client.
Have you received?
My lord, we received it.
Yes. Who is
We
for the
received it.
plaintiff?
They're not appearing today.
Not today.
My lord.
My lord, in item number 4, I am for the defendant, my lords. My
But,
lords,
my lord, the affidavit in opposition which was directed to be filed by the
for the plaintiff, my lord.
This is an application for discovery of an additional document filed by the plaintiff, my lord. Lordship had directed us to file an affidavit. We were little out of time. We served them. They refused to accept because it was out of time.
Yes.
My lord, it was supposed to be filed by 24th of June. We served them on 7th of July. So, my lord, possibly because there was no extension.
They have served a copy, my lord. My advocate on record initially refused, but thereafter they have served it by way of an email. My lord, I'll require 1 week time to file, my lord, the reply, my lord. They have filed it belatedly.
Defendant has filed affidavit in opposition in connection with GA2 of 2020, GACOM 2 of 2025. Let the same be kept with the record. The plaintiff is directed to serve the copy of the opposition to the learned counsel for the plaintiff by tomorrow. Plaintiff is at liberty to file affidavit and reply within a week thereafter. Please the matter on 12th of August.
Great.
Grateful, my lord.
Under the heading adjourn motion. Yes.
Well, I was for the plaintiff respondent. This GA is by defendant number 1 and 2. I do not think they're appearing, my lord.
Yes. You are appearing for?
The plaintiff respondent. This application is by defendant number 1 and 2.
My lord, there are two applications on the board. My lord, I appear for the defendant numbers 1 and 2.
Yes. What application you have filed?
My lord, my application is for deletion. My lord, am I audible?
GA number?
My lord, GA number 4.
GA4 and what about the GA3?
My lord, GA3 has not been taken out by defendant number 3 and 3 to 5.
You are appearing for whom? Defendant number 1 and 2?
Numbers 1 and 2.
Okay. So
No, I'm being led by Mr. Deepnath Rai Chaudhary.
Whether you have filed affidavit in opposition?
Affidavits are complete, my lord.
Affidavit filed? Affidavit filed? Reply? Aditya?
Are you appearing now?
Yeah, affidavit in opposition. Okay, ठीक है. The defendants have filed an application being GA Com 3 of 2025 and GA 4 of 2025. It is found that the readings have been completed. Let both the application be fixed on full stop, completed full stop. Let the matter appear on 12th of August 2025 for hearing of both application under the heading adjourn motion.
Grateful.
Next.
Grateful.
My lord, I'm sorry. I have a request from the defendant number 1 and 2 to place their reply on record.
Affidavit in reply of GA which? GA? GA 4.
GA 4.
Be kept with the record.
Grateful.
Yes, next.
I appear for the defendant petitioner. There are two.
I appear for the plaintiff in the matter, my lord.
So the first application is my Section 8 application. Section 8 versus Section 5. I've sought GA2. There, my lord, we received the affidavit in opposition. May I file my reply? And my lord, GA3 is my application, my lord, for acceptance of my written statement. There, my lord, there was liberty granted to the plaintiff to file an opposition. We've been.
Where is the affidavit in opposition of the plaintiff of GA2? Who is appearing for GA2?
My lord, I appear for the plaintiff, my lord, in this matter.
These are affidavit in opposition in connection with GA2.
My lord, we have a copy. If my lord, we have a copy, we've been served and we've prepared a reply.
You're not filing the court.
My lord, may I only indicate, my lord, the difficulty. I've just been informed, my learned advocate on record, is some difficulty today, my lord. They have not been able to reach court. It is only on that ground, my lord, that I'm seeking an adjournment, my lord. If it could be kept, my lord, on Wednesday.
For something, my lord, if it commences to, my lord. My lord, I'm ready in the matter, my lord. If my lord hears me on GA2, because affidavits are complete, I can hand up a copy of the opposition as well. At least my part of the arguments can be concluded. My learned friend is there, my lord.
But he's having some difficulties telling that.
My lord, I could only humbly pray so as to utilize the time.
Take, but he is having some difficulty.
If
yes, Mr. Sen, can the matter be taken? He can argue the matter.
My lord, I possibly would not have an objection to that fair statement, my lord, but I have been instructed, my lord, my learned advocate on record was not able to reach the court, my lord. So I am under instructions to take an adjournment. But if it commends to, my lord, to allow Mr. Mukhopadhyay to commence arguments, my lord, I cannot stand in that way.
Counsel for the plaintiff has filed affidavit in reply in connection.
My lord, counsel for the defendant petitioner. I am the petitioner.
Counsel for the defendant filed affidavit in reply in connection with GACOM 2 of 2025. Let the same be kept with the record. Let the matter appear tomorrow under the same.
My lord, GA3, my lord, they've given us a copy of the affidavit in opposition belatedly. My lord, kindly
GA3?
That's my application for acceptance of my written statement. It was filed before court within 120 days, no difficulty. They filed an opposition. My lord, grant me a week's time to file a reply to that.
GA3 में देखो affidavit opposition है.
I believe he'll face the same issue. He served a copy on me, but I don't think it's been filed.
So called the data. Counsel for the defendant submit that he has received the affidavit in opposition in connection with GA3 and he seeks time for filing reply.
Affidavit in reply.
And prays for time to file, prays for extension of time to file affidavit in reply. Let affidavit in reply be filed within a week from date. Let both the application be listed on.
My lord, could it be on Wednesday if it commences to my lord's convenience?
Being kept after a week after affidavit, my lord, we'll keep it after a week then.
Very good.
Any day apart from 30th, my lord, we'll kindly keep it. Apart from 30th, any day.
On 1st of August.
Obliged.
I'm deeply obliged, my lord. I'm deeply obliged.
Obliged.
I appear on behalf of the defendant petitioner my application for revocation of leave under clause 12 of the letters patent. So if I had completed my argument, to my learned friend on the other side was to reply, but
Lord, Mrs. Tottu is appearing. She has not come to court. Kindly make it not today.
Not today.
My lord.
Not today. Not today. Not today. Not today. Not today.
Lordship, I appear for the plaintiff petitioner, Lordship. GA2 is their injunction application. GA1 is our injunction application. They had filed a counterclaim, Lordship. GA3 is for acceptance of the written statement, Lordship. So the pleadings are complete. I'll just file my reply, Lordship.
In which you are filing the reply?
GA3, Lordship.
GA3 is your application.
Yes, for acceptance of the written statement to their counterclaim.
Counterclaim.
Yes, Lordship.
Within time.
Within time, within
120
120 days, outside 30 days.
Who is for the other side? And what about the J1 and J2 plead is completed?
Lordship, pleadings are complete.
Not for the defendant.
Yes, I wait for the plaintiff.
Plaintiff.
Yes.
It's for the defendant. In J1, J2 pleadings completed?
Pleadings are complete, my lord.
That means all applications pleading
Yes,
are complete.
pleadings are complete. My GFU.
Then advocate appearing for the plaintiff submit that. We are filing affidavit reply.
My lord, reply in GA3, that is our, my lord, application for extension of time
has filed
for taking the WS on
affidavit
record.
in reply
Counterclaim.
in connection with GA-Com 3 of 2025. Let the same be kept with the record. It is submitted that in connection with all interlocutory applications, pleadings have been completed. In view of the above, let all the application be fixed for hearing on 6th of August 2020. Next.
Grateful, madam.
But I'm appearing for the respondent. There are 3 GAs. This is in all the GAs, pleadings are complete except in GA7.
You are appearing for whom?
Respondent 1 to 4.
No, respondent plaintiff or dependent?
Defendant.
Dependent.
My lord, I was appearing for the plaintiff. My lord, lordship kindly fixes it any other day. Interim order is expiring tomorrow, my lord.
Yeah, pleadings have been completed in all applications?
Yes, my lord. Pleadings are complete.
You are filing?
Except GA7.
What you are filing?
Affidavit in reply.
Affidavit in reply. Counsel for the defendant has filed affidavit in reply in connection with GA7 of 2025. And let the same be kept with the record. It is submitted that pleadings in connection with all applications have been completed and is ready for hearing. In view of the above, let the matter appear on 12th August 2025.
My lord, the interim order in GA1 is expiring tomorrow. My lord, kindly that be extended.
Counsel, I am extending the interim order.
Yes.
Counsel for the plaintiff submit that the interim order is only up till 22nd of 2025 and pled for extension of interim order. In view of the submission made by the counsel for the plaintiff, interim order is extended till 18th of August 2025 or until further order, whichever is earlier.
Very grateful, my lord.
Not today. Not today. Not today.
I appear for the defendant number 2. My lord, there is an application that has been filed by the defendant number 1 under section 8 of the Arbitration Act, which I am opposing. My lord, my affidavit in opposition is ready. My lord, may I file it?
Who is for the plaintiff?
I am for the plaintiff, my lord.
So you will file reply.
No, my lord, it's an application by the defendant number 1, my lord, under section 8 of the Arbitration Act. We have
filing reply.
No, my affidavit in opposition to the section 8 application.
Section 8. You are for the defendant number 2?
Yes.
You are for the plaintiff?
My lord, I am for defendant number 1.
You are for the plaintiff?
Yeah, Mr.
I am for the plaintiff.
Who has filed the section 8 application?
Defendant number 1 has filed.
Defendant number 1 has filed.
My lord.
Have you
my
received?
Lord, I am for the defendant number 1, my lord.
Yes.
I am instructed to submit that we will be filing an affidavit in reply, my lord. My colleague is on the way to the honorable court to hand it up. If I may get some time to file it.
Affidavit in reply to the affidavit in opposition of the defendant number 2.
Yes, my lord.
And you file the affidavit in opposition?
Yes, my lord. Long time.
Section 8 application. And you, what is the GA number section 8 application?
It's a 3 of 2024.
3 तो नहीं है.
No.
3 तो है नहीं.
4.
Yeah, 4.
4 देखो. GA4 and GA5, there are two applications are there.
But the 2024 GA is the section 8 application.
GA4 2024. Give both applications.
My lordship, I'm just filing an affidavit in reply to the same.
It's GA4.
GA4.
Give me a copy.
GA5 is for extension of time to file return statement by the defendant number.
Oh, you have already that has been disposed of.
1.
GA5.
Where is the GA4?
GA3 then.
GA3.
GA5 has been disposed of. So
GA4 is the section 8.
Yes. To which my affidavit in opposition has been filed. The reply has now been filed by the second defendant.
You also file the affidavit.
yes, my lord. We have filed the plaintiff.
You also file the reply to the affidavit of.
I have my. It's ripe for hearing.
And
my
what about the GA5?
My lordship, I think GA5 can be taken up possibly after determination of GA4, since if GA4 is decided in my favor, GA5 may not need to be decided.
The defendant number 1 has filed affidavit in reply in connection with GA.com 4 of 2024. Let the same be kept with the record. It is submitted. The pleadings in connection with GA4 is completed. Let the matter appear on 13th August 2025 for hearing of GA4.
She will kindly
Lord, one in
time, my lord. Date and time, my lord. So far.
Time, then it will go to the September or August.
Okay.
My lord, only one indulgence. My lord, my written statement, my lord, was prepared on 23rd of June 2025. It is within the 120 days period. But my lord, the department is not accepting as your.
When your 120 days going to expire.
My lord, the plain copy was given to us in the month of my lord, 4th of April 2025.
File in the department.
But department is not accepting.
Record. Give. Where is the written statement?
Yes, this is
affirmed.
Yes, affirmed, my lord. Vakalatnama competency all, my lord.
On behalf of the plaintiff, my lord, the written statement, I think it's beyond 120 days.
No, it cannot be 120 days.
It was served.
No, that's why let they file in the department subject to acceptance.
Yes,
You have filed an application.
Yes,
No application.
Application has not been filed because it was prepared and affirmed within the 120 days period.
Take. The
competency
leave is granted to the defendant number 2 and
defendant number 2.
Leave is granted to the leave granted to the defendant to file submit the written statement in the department subject to acceptance.
Yes, along with the vakalatnama and competency.
Subject to acceptance along with the vakalatnama and competency. In course of the day.
During course of the day. Great. Yes. Great.
13th August.
21, my lord, I am for the plaintiff, my lord.
Yes.
This matter was transferred to the commercial division, my lord. Thereafter, my lord, certain documents has to be filed, the statement of truth, and that has not been filed yet.
You are for the plaintiff?
I am for the plaintiff, my lord.
What is the GA3?
GA3 is my application, my lord, that I have submitted an amount of money with the original side. Regarding that, the defendant has submitted, there will be a counterclaim, but no counterclaim has been filed. Written statement is already filed. I have filed that application for recovery of that amount.
So what you want now?
But week's time may be given to file the statement of truth and things.
Counsel for the plaintiff prays for a week's time to comply with the provisions of the Commercial Court Act. 2 weeks time period. 2 weeks time to comply with the provisions of the Commercial Court Act. Consider the submission made by the counsel for the plaintiff. Plaintiff is directed to comply with the provisions of the Commercial Court Act within 2 weeks from date. Release the matter on 12th August 2020.
Deeply obliged.
Next.
The 22, I appear for the plaintiff. The defendant was making his submissions. It's an application under Order 7, Rule 11. Now, Mr. Bagh was appearing.
Yes, Your Lordship, I am for the plaintiff. I'm led by Mr. Dasgupta.
Not today.
Grateful. Your Lordship.
Grateful.
Not today.
But I appear on behalf of the plaintiff, my lord. I have not filed an application for registration of the suit, my lord. It was not dismissed. And your lordship, my lord, on the last occasion was pleased to ask the department to bring the original record, my lord, of the CS.
Where is the order?
Order dismissing my application is page 13 of my application, my lord. No, the reasons I have stated in my para 6 and 7 of my application.
Yes. You're not appearing. You're appearing.
But I have been appearing, my lord, but there was some difficulty to.
What is the stage of the suit?
My lord, so far as the stage of the suit is concerned, my lord, I have obtained report from the department, my lord. Defendant number 1 and 2, although was served, but they have not, my lord, entered appearance.
Okay.
And my lord, we have, my lord, also obtained an interim order at the initial stage when it was, my lord, contested.
What about the defendant number 3?
So far as defendant number 3, not kindly sees the report is this. They say, my lord, department says that postal acknowledgement material receipts to GPO Kolkata with Srimak CPN, postal acknowledgement of the receipt for the defendant number 2. Neither the postal acknowledgement receipt nor the undelivered packet for the defendant number 1 and 3. So department is saying that they do not have the postal acknowledgement record.
The plaintiff has filed the present application being GA Com 3 of 2025, praying for recalling of the order dated 17th April 2025, wherein this court has dismissed the suit for default. Consequently, all interlocutory applications were also dismissed. Counsel for the plaintiff submitted that due to the illness of the learned advocate on record, the learned advocate on record failed to appear before this.
But not on the ground of illness, my lord. I have not stated illness.
Conducted counsel indisposed owing to the illness.
Yes, contacting models, but the advocate on record was my lord, was before some other court, my lord.
Then they submit that the conducting advocate was suffering from illness, and the learned advocate on record was on leg before the another court when the matter is called according and due to which neither the conducting counsel nor the advocate on record appeared before this court, and this court has dismissed the suit for default. Let the learned counsel for the plaintiff peruse the reasons shown in the application. This court find that sufficient reason has been shown as to sufficient cause has been shown as to why the plaintiff has not appeared before this court on 17th April 2025. Accordingly, order dated 17th April 2025 is recalled. CS Com 291 of 2024 within bracket old CS 152 of 2021 along with IAGA 1 of 2021 are restored in its original file. This is the matter.
My lord, on 8th October 2021, my lord, I also obtained an interim order, my lord.
It is restored or restored.
My lord, can you want to indicate in the order, my lord?
It is actually this is the matter. GA number so is disposed of. List CS Com 3 of 2025 along with GA on 13th of August 2020.
May I take back the?
Yes.
But in the
Grateful, my lord.
matter, I'm appearing from the plaintiff petitioner. This is today the application for admission before judgment has come, but on the last occasion, your lordship had been pleased to pass an order directing me to pay rupees 50,000 as cost for non. So that order, and I have paid that lordship. And to
Yes.
I have already paid that.
You are appearing for whom?
I'm for the plaintiff petitioner.
Yes.
That's. So today it has appeared. Today the application for judgment upon admission has come, lordship.
Yeah.
We have already paid the cost, lordship. Lordship, today it is the other side is also today it is the application has come in before your lordship. So
who is for the other side? Have you served?
Yes, lordship. Have you served? Affidavit service served. Lordship, it is on the record, lordship. We have served, but the other side is not here today because probably of that disruption.
Not today.
Lordship kindly records the payment of the cost.
So appearing for the plaintiff. Plaintiff has paid the cost in terms of the order passed by this, paid the cost to the State Legal Service Authority in terms of the order dated 26th June 2025. Let the receipt dated 30th June 2025 be kept with the record. The plaintiff has filed an application being GA Com 5 of 2025, praying for judgment upon admission, but none appears on behalf of the defendant. Accordingly, case adjourned. Let the matter appear tomorrow.
Lordship.
Next.
Lordship, I am appearing on behalf of the plaintiff. GA 4 and 5 pleadings are completed. It was posted for hearing. If I may request one small indulgence, your lordship, Mr. Shomava Ghosh is appearing in the matter. He's traveling due to some work commitment. If the matter can be kept any day next week.
Who is for the other side?
Mr. Rupak Ghosh is appearing.
GA1 is, what is the GA1?
GA1 is for occupational charges and GA2 is for summary judgment. Both have been reserved for
GA1 is
for occupational charges. And GA2 was for summary judgment.
Correct.
Both have been reserved for judgment by Justice Arindam Mukherjee.
Okay.
So GA5 is for rejection of plaint. It's their application. And GA4 is my application. It's for directions on KMC to produce certain documents like the sanction plan. So GA4 and 5, your lordship, wanted to hear out on the next.
Pleadings
Pleadings are
completed.
completed, Your Lordship.
It is submitted by the learned counsel for the plaintiff in connection with GA4 and GA5.
GA4 and GA5.
GA5, GA-Com 4 of 2025, GA-Com 5 of 2025. Pleadings have been completed and matter is ready for hearing. As none appears on behalf of the defendant, accordingly, case is adjourned. Let the matter appear on 13th August for hearing of GA4 and GA5 of 2025 under the heading adjourned motion. Next.
Great.
Not today.
30, my lord, I was appearing for the petitioner, but my application for production of a document in order to answer a case set up by the defendant subsequent to the suit. Lordship would remember the defendant has not been appearing for a while, after their application was dismissed by your lordship. This is the matter which your lordship had decided. Defendant had took up a point with regard to the territorial jurisdiction of this court because the plaintiff's office at the time of entering into the contract was outside the jurisdiction. So the defendant took this point of territorial jurisdiction, which your lordship had decided against them. But thereafter, they have not been appearing. Now, I have taken out this application for bringing on record a public document, the form by which I seek to establish that the registered office at the time of institution of the suit was within the jurisdiction. That is the long and short of my application.
You are appearing for?
My lord, I'm appearing for the plaintiff petitioner in this matter, my lord. The matter has already been set ex parte, my lord.
Yes, this is an undefended suit. The suit is undefended.
So what you want now? What is the application? Give what is the application?
The application, if your lordship kindly takes page 33, although today there is a resolution, but it's only that defendant has not been appearing for a while.
Have you served?
We had attempted to serve before, but it came back. The item was refused or unclaimed. The addressee not found. These were the endorsements.
So you have to take steps.
My only concern was, since this is an undefended suit, the defendant, of course, has the right of cross-examination.
My lord, may I perhaps indicate, my lord, this instant application was not served because the suit was already made ex parte before we filed this application, my lord.
So this the document which you are we want to bring on record. What is the date of the document?
Well, this we have downloaded from the Ministry of the website of the Ministry of Corporate Affairs, which you will find at page 33. Lordship will see towards the middle of the page, the serial number 4. Towards the middle of the page, notice is hereby given that the address of the registered office of the company is situated with effect from 30th September 2022. Lordship has found that. Thereafter, the address of the plaintiff is given 41A Agency Bose Road, which is situated within the jurisdiction.
Yes.
Now, this document, it's not that this document was not available with me at the time of filing the suit. But this comes under Lordship will see Order 11, the sub rule which says that no document shall be permitted to be disclosed unless it is in answer to a case set up by the defendant subsequent to the filing of the suit. The defendant had taken this point that at the time of entering into the contract, the office was situated outside the jurisdiction, and since there is a confusion with regard to the address of the registered office of the plaintiff, so this court may not have the territorial jurisdiction. So, that is why this document is required to be brought on record to show that the plaintiff's registered office is situated within the jurisdiction. The address has been given in the cause title, but this is the supporting document. If your lordship kindly takes the amendments to the Commercial Courts Act,
So how you can say that? Because it is your document, your plaintiff, you could have been having this document on that day at the time 2022 year at the time of filing of the suit, the cause of action was within the jurisdiction. So you are not
Yes, but
how this
I'll indicate. Malad, I'll indicate. Malad, in the cause title, Lordship will see in the cause title of the plaint, I have given the registered address of the plaintiff, which is now situated within the territorial jurisdiction. So, Malad, there was no dispute with regard to my office being situated within the territorial jurisdiction of this court, and this court's consequently having jurisdiction to try this suit.
Correct.
Now, Malad, after the suit was instituted, in an interlocutory application, the defendant took a point that the registered office situated was outside because at the time of entering into the contract, the office was situated outside. And since there is no supporting document to show that the plaintiff has its registered office within jurisdiction, so this court may not have the territorial jurisdiction. This was the defense taken.
Correct.
So that is how I fall under Order 11, Rule 1, Sub-Rule 1, if your Lordship kindly takes the amendments to the Commercial Courts Act.
With the Commercial Court Act.
But Order 11, Rule 1, if your Lordship takes.
Yes.
But Rule 1, Sub-Rule 1C. Nothing in this rule, may I place, my lord? Nothing in this rule shall apply to documents produced by plaintiffs and relevant only, then, my lord, Sub-Rule 2, in answer to any case set up by the defendant subsequent to the filing of the plaint.
Correct.
So, my lord, that is how I fall under this ground, this provision, that at the time of institution of the suit, my lord, I need not have produced the document.
See, correct. But you have to file, kindly come to the clause to Order 11 Rule 2. The list of documents filed shall be specified that you know the document and you have to file the affidavit. Correct. You file the affidavit. And subsequently, if you want to file, bring on documents of document, then you have to show that document was not in your hand and that document was came late subsequent to filing of the suit. But what the document you are relying upon, that document belongs to you of your registered office address, and that is your address. How you can say that that was not in your hand at the time of filing of the suit?
May I only place Order 11 Rule 1 in its entirety? In its entirety, instead of placing only one provision, may I place Order 11 Rule 1 in its entirety? Order 11 Rule 1 Sub-Rule 1 says, plaintiff shall file a list of all documents and photocopies of all documents in its power, possession, control, or custody pertaining to the suit along with the plaint.
No
Now it says whatever documents is in my possession, I have to file it with the suit.
Correct.
Now then comes Sub-Rule 1C that says, nothing in this rule shall apply to documents produced by plaintiffs and relevant only in answer to any case set up by the defendant subsequent to the filing of the plaint. So, the precondition that whatever document I possess will have to be filed along with the plaint will not be applicable if it is in answer to any case set up by the defendant subsequent to the filing of the plaint.
Correct. Nothing this rules apply to the document produced by the plaintiff and relevant only for the purpose of cross-examination. That's why what the document you possess. It is not that you can produce the document subsequent to the filing of the written statement. That is not the answer of this this provision.
C2,
read the total. First you read the Order 1, then come to the Order 1 Rule C. Order 11 Rule 1C. First, plaintiff shall file a list of all documents and photocopies of all documents in its power, possession, control, or custody pertaining to the suit along with the plaintiff, including this. Nothing this rule shall apply to the document produced by plaintiff and relevant only for the prosecution. So you have to produce all the document. It is not that it is required or it is not required. What document you have to produce at the time of filing of the case. Now your case has come under the 4. Now come to 4. In case they are filing not, in case the plaintiff shall not be allowed to rely on document 5. Come to 5.
5. Yes, Ballot 5.
Shall not be allowed to rely on document which were in the plaintiff's power, possession, control, or custody and not disclosed. So this document is within your custody. It is your document. It is not that this is a document of the defendant. Subsequently, you have taken out from the website. It is your document. You cannot say this document was not with you.
But I'll tell my lord. My lord, insofar as subsection 5, subrule 5 is concerned, that says that no further documents will be allowed to be produced unless your lordship is satisfied with regard to the reasonable cause for non-disclosure along with the plaint.
Correct.
Now that is the purport of subrule 5. Subrule 1 says plaintiff shall have to file all documents in power and possession of the plaintiff at the time of filing the plaint. Now, my lord, I am only harping on Order 11, Rule 1, Subrule 1, C2. C says nothing in this rule shall apply. So, my lord, it starts with nothing in this rule shall apply, which means that whatever, even if the plaintiff has in its power possession some document, that precondition will not apply if then I come to then fall under 2, C2. In answer to any case set up by the defendant subsequent to the filing of the plaint. But the defendant, because at the time of institution of the suit, I do not know, I will never know what the defendant will come up. Now, whatever is required to prove my claim, I have submitted along with the plaint. Now, my lord, in answer to any case set up by the defendant, because the defendant had set up this case that my registered office may not be within the territorial jurisdiction. So that is why, in order to answer that case, I am producing this document, and this is a public document. It's not that it's my internal document. It's a public document where I say that my registered office had long shifted since 2022, prior to the institution of the suit. And since the defendant is setting up this defense, I am saying that this is the document which would support that my office is within the territorial jurisdiction. So that is only this document is only in answer to a case set up by the defendant. And insofar as subrule 5 is concerned, insofar as the reasonable cause for non-disclosure along with the plaintiff is concerned, I could not have known that the defendant would set up this case, that my registered office is not within.
As per as my thinking on 1C, nothing these rules shall apply to the document produced by the plaintiff and the relevant only. So, as per the provision, whatever the document you file, it is not necessary that it is set up only for the defense. Whatever the document you have to file, it is not that the subsequent to filing of the written statement, you again have to set up a new document. This is not the provision. So, what would be the purpose of subrule 5? What would be the purpose of subrule 5? The interpretation of you want, I will give the interpretation. This is only whatever the document you are having, you have to file along with the plaint. So but the document which you have filed, it is not necessary. It is to set up the defense what the defendant has disclosed. It is not necessary all the documents relevant, but you have to file all the documents with regard to connection with the case. And with regard to you want to file the another document, then the 5 will applicable. And the 5, you have to satisfy this court.
But I've understood your lordship's view. But if your lordship could kindly give me 1 or 2 days time, I'll try and satisfy your lordship on the interpretation.
Satisfied, yeah, no problem. I will give the time, but it is the court's view.
I have understood.
To all documents, 1C, whatever the document is filed, nothing. It is not necessary that is only connected with the written statement. Whatever it is not required, but you have to file it.
Written statement is not required at all. Written statement, the provision also says in answer to any case set up.
Counsel for the plaintiff has filed an application being GA-5 of 2025, praying for bring one document on record. Add additional document. Full stop. Counsel for the plaintiff press for time. Accordingly, case adjourned. Let the matter appear on 12th August. Next.
I'm grateful.
Grateful, my lord.
My lord, 31, my lord, I am appearing on behalf of the plaintiff, my lord.
Yes.
My lord, in this matter, my lord, GA1 is my injunction application and GA2 is an application for judgment upon admission. My lord,
GA3?
GA2, my lord. And my lord, in GA1, interim order was existing till 14th July. That's why matter was mentioned before the Honorable Justice Sugato Majumdar, my lord, and interim order has been extended till 22nd, my lord. Interim order is my lord, subsisting till tomorrow, my lord. And my lord, in respect of GA2, I am praying for not today, my lord, since my counsel is not here, my
Who
lord.
is for the other side?
No, defendant has not yet appeared, my lord.
Not appeared?
No.
So you are not filed, and you are not served the copy?
No, copy was served. It returned, my lord, with postal remarks left, and it has been recorded by your lordship in order dated such, my lord, that order dated 9 June. The matter has been fixed. My lord, paragraph 10, my lord. Paragraph 7, my lord. Unclaimed, my lord. Sheriff report was also called on, my lord.
Yes.
Well, I'm only praying that interim order may be extended, my lord.
Why not today?
My lord.
Why not you are arguing the matter?
My counsel is not there, my lord. That is the problem.
I am not extending the interim order. I am not extending. You are taking the benefit of the interim order and taking the time. I am not extending.
No, my lord. Interim order is still tomorrow, my lord.
If you are ready, I will hear the matter. I will not extend the interim order.
My lord, kindly then, my lord.
The court is not a sophist.
No, my lord.
Only for extending the interim order.
No, my lord.
If it is undefendant suit, why you are not ready with the application? It is not the case the plaintiff is not appearing. You are appearing. You could have been get ready with the matter. Yes, call the next matter.
May I pray for my lord short passover, my lord then? May I ask for my counsel, my lord?
My lord, item number 32, my lord. I beg to appear for the plaintiffs, my lord. My lord, GA1 and GA2 are my application, my lord. GA1, my lord, we had filed an application seeking injunction, my lord, on the property of, my lord, the defendants, my lord, because there was an admitted sum, my lord. Your lordship was pleased to pass an order, my lord, directing, my lord, the respondents to not to deal with that property. However, my lord, thereafter, my lord, the defendants informed us that prior to your lordship having passed that order, they had sold that order by way of a registered deed, my lord.
Correct.
Subsequently, my lord, GA2 was taken out, my lord. We prayed before your lordship to direct, my lord, them to secure the amount which was admitted by them, either by way of bank guarantee, my lord, or before the registrar, my lord. Thereafter, my learned friends, after, my lord, taking, my lord, extensions, have filed an affidavit in opposition, my lord. We, my lord, have prepared our reply, my lord. I wish to, my lord, file the affidavits in reply, my lord, today before your lordship's court, my lord.
Of GA1?
In respect of GA1 and 2, both, my lord. They have used an opposition in respect of both.
Opposition or a reply?
We have used opposition in both. We are filing reply in both, my lord.
So other part, who is the other side?
Mr. Banerjee, with your lordship's leave, Mr. Banerjee, Mr. Shuddha Banerjee is appearing. But as a matter of fact, they have also filed an application.
What?
That is for a revocation of leave under section 12. But I don't think I need to file an affidavit to that. But it's not appearing in lordship's list because it is covered by the division bench judgment by now. So, my lord, that is not appearing. Today, my lord, we don't.
Plaintiff has filed affidavit in reply in connection with GA1 and GA2. In connection with GA-1 of 2025 and GA-2 of 2025. Let the same be kept with the record as none appears on behalf of the defendant. For the interest of justice, the case is adjourned. Let the matter appear on 12th August.
Interim order? Last week of July. The interim order, I believe, it is to whatever is worth. Because they have not yet been able to show that they have disposed of the property.
Interim order is extended till 11th or 12th. Is extended till 14th of August 2025 or until further order. Next.
33, my lord, I am appearing with a respondent. Can I keep it tomorrow, my lord? Mr.
Lordship, I'm
Banerjee is appearing, my lord. He has requested not.
Lordship, I'm appearing for the petitioner, Lordship. This is my application, which I wanted to move ad interim, Lordship. But on the last day, Lordship was of the view that we serve them a copy of the petition, Lordship. We have served them a copy. I have made
We have received the copy of it.
I have made a affidavit of service.
I have received, my lord. I have received.
Lordship will keep it tomorrow since although today. Yes,
not
Lordship.
today. Not today.
Good.
एक मिनट अच्छा 6 मिनट
Wait, please.
The matters listed today for my rejoinder to what Mr. Bose has been arguing for the last 2-3 dates. Now I'll try to be very brief. I'm not going to repeat what I've already argued, but I'll just give in their reply, they've given 4 broad defenses. One is res judicata. Second is the proviso to Order 21 Rule 58. Third, alternative remedy under Section 30 Companies Act. And fourth, on merits that no fraud has been made of. I'll address each one of them to show how they are misconceived. As far as res judicata is concerned, before we get into what the contention was, if I may just
Yes.
Before I get into what the contention was, I'll formulate the contention, because the reason why I'm having to do this is that the pleading says something, oral arguments saying something else, new layers introduced from oral arguments, and that's the reason I sought time to give that response. To start with, defense of res judicata is a matter of trial.
Yes.
It cannot be decided summarily by seeing one judgment of the Honorable Division Bench or by their pleading only. The Supreme Court has time and again laid down that whenever there's a defense of res judicata, it has to be put to trial. The pleadings, the issues, the decisions of the former suit need to be seen.
Yes.
Those facts need to be proved. And then only the question of application of res judicata.
Yes.
I had cited one judgment in this regard. I won't take much time on that, but just to, because there has been a gap between what was argued between the hearings. This is this index I had given on 20th January 2025. The decision of the Supreme Court on 2020. This is the third case on page 2. I'll just read only from the head mode. I won't trouble the court with the judgment. This is what is a proposition I have called out. Court will just see only that only the court has this judgment.
That one.
This is of 28 January 2025. Shri Hari Hanumandas Totala 2021 9 SCC 99.
Given separate citation?
No, it's already. I've already given that on 28th. I've handed that over.
28
January 2025. There are 3 judgments in that. One was on the issue of.
Yes.
And I'll just read only from the proposition I've called out on page 2. I won't trouble the court with the judgments. I don't want to repeat myself. Page 2, third judgment, second proposition. This is what the Supreme Court says. Plea of res judicata.
Third judgment is Sri Hari.
So Shri Hari Hanumandas.
Yes.
The second proposition, plea of res judicata cannot be determined merely by looking into the averments in the plain. Such a determination would require production of pleadings, issues framed and judgment in the previous suit to compare it with the present suit. This exercise could not be undertaken merely by looking into plain averments, but upon trial of the suit. For the purpose of invoking Order 7 Rule 11, no amount of evidence can be looked into it. The issues and matter of the matter which may arise between the parties would not be within the realm of the court at that stage. All issues would not be subject matter of an order under the said provision.
Yes.
So the very defense, what they are saying, is a matter of trial. The way my objection to the Order 21 Rule 58 is a matter of trial. If I may just hand over a more recent judgment order passed by the Supreme Court along the same lines. It's a very short order. I'm giving a copy to my learned friend, where the same proposition has been reiterated, because we are in the realm of order. If my objections have been tried as a suit, we are in the realm of Order 7 Rule 11 proceedings, even out here in objections. If I may, it's a very short order. I'll just read it. The appellant is the original defendant. He applied in the suit filed with respondents for the rejection of the plaint under Rule 11 or Order 7 of the CPC. written statement was filed by the appellant raising the contention of bar of res judicata. In the application filed by the appellant under Rule 11 of Order 7 CPC, reliance was placed on several documents, order of various courts. Learned single judge rejected the plaint under Order 7 Rule 11 of CPC. In appeal preferred by the respondent plaintiffs, a division bench of the High Court has interfered on merits by holding that the plea of res judicata recorded by the learned single judge was not correct. After hearing the learned counsel appearing for the parties, we find that the plea of res judicata could not have been gone into an application made by the appellant under Order Rule 11 of Order 7 of CPC. Apart from the pleadings in the earlier suit, several other documents which relied upon by the appellant in his application under Rule 11 of Order 7 of the CPC were required to be gone into for deciding the issue of res judicata. As far as the scope of Rule 11 of Order 7 of CPC is concerned, law is well settled. Court can look only into the averments made in the plaint and the highest documents produced along with the plaint. The defense of a defendant and documents relied upon him cannot be looked into while deciding such application. Hence, in our view, the issue of res judicata could not have been decided on application under Rule 11 of Order 7 of CPC. The reason is that the adjudication on the issue involves consideration of the pleadings in the earlier suit, the judgment of the trial court, and the judgment of the appellate courts. Therefore, we make it clear that neither the learned single judge nor the division bench at this stage could have decided the plea of res judicata raised by the appellants on merits. Therefore, we finally agree with the conclusions of the division bench of the High Court. The suit needs to be decided on merits, with the modification that the issue of res judicata will remain open and learned single judge will frame an issue on res judicata along with other issues. Yes. So this has to go for trial even on res judicata. Now, coming to the facts of this case, the court is, where it pointed out the matters pending before the NCLT, got nothing to do with fraud, etc. That's on the issue of management oppression. But a similar defense was raised before the Honorable NCLT, that those proceedings are barred by res judicata. The court will recall Supreme Court said you can pursue before this court and for NCLT. I've handed over the NCLT orders up till the last date. These are the subsequent orders that have been passed by the NCLT. I'll just give a copy to my learned friend. If I may just hand this over. I'll give a copy to my learned friend. If I may just summarize before I take the orders.
Yes.
What has happened is the NCLT has got rid of the earlier directors.
Yes.
New directors have been appointed.
Yes.
An application being filed. My learned friend is preparing for the new directors. Also moving objections that separate on behalf of the JD. Because Starlight Augustus is my subsidiary. Pursuant to the orders of the NCLT, which I'll take the court through, I was allowed to appoint directors on Augustus, and Augustus has to nominate on Astor.
Yes.
So, pursuant to the directors who've been appointed under the orders of the NCLT, fresh objections have been has been filed, and we are seeking it may be listed tomorrow when the matter is taken up again. Tomorrow at 11:30. The matter is fixed for tomorrow also at 11:30. But before I come to that, on the issue of res judicata, court may come to page 5. That's your order.
So you mean to say that has been raised in the
NCLT also. And this is where I'd appeared before the Honorable Tribunal. This is the order of 4th of April 2025.
Yes.
The court may just see IA 51 on page 5. Learned counsel for the applicant presses the application on 2 grounds: limitation and res judicata, and submits that the issue of maintainability ought to be decided first before proceeding on the merits. This bench has considered submission and judicial precedents in this relation and is of the considered view that both these grounds should be considered at time of final hearing, as those grounds involved mixed questions of law and fact. Accordingly, these 2 grounds cannot be considered the host and merit of the petition. Hence, the parties must advance arguments on merits as well as maintainability together. So, in this very case, between the same parties, this is the view taken by the Honorable NCLT on the issue of res judicata.
Okay.
So, my first submission when we talked about res judicata was basically it's a matter of trial, and in light of that, the decision cited by my learned friend Asgar's case, the court will recall, where that case is only authority for the proposition that when the Supreme Court relegates parties back to another forum and leaves the questions open, it is permissible for the other side to raise the defense of res judicata. But that's a defense to be tested at trial.
Correct. Okay.
That's not authority for the proposition that can be decided in the realm of Order 711.
Yes.
I'll come to these orders when I come to 430 of the Companies Act. I'll come to each of these orders, show what has happened before the NCLT.
Okay.
Now, what is the submission on merits for res judicata? What do they say? They say the Honorable Division, single judge disposed of the suit partially. Matter went before the division bench.
The total matter was taken up by the Honorable Division Bench, and Division Bench has considered all.
Has said that there is no cause of action to file the suit. And so the argument is, since there is no cause of action to file the suit, there is no cause of action to file the objections on similar pleadings. And so, when the Supreme Court has given us liberty to go back, relegate back, it has to be as per law. So the objections filed by the Supreme Court, objections filed pursuant to the liberty given by the Supreme Court, are barred by res judicata. This is the argument, and it is wholly misconceived. Few dates are important to show the fallacy in the argument. The learned single judge's order is dated, I'll just give only the dates. 14th May 2015 is the learned single judge's order. Appeals were filed before the May 2015.
Yes.
Appeals were filed in 2015. During the pendency of the appeal before the Honorable Division Bench, the petition was filed before the NCLT on 29th November 2017. The Division Bench order is 3rd of December 2019.
Yes.
Against the Division Bench order, the SLP was dated.
What is the Division Bench order?
3rd December 2019. So the NCLT petition had already been filed.
Okay.
On 13 December 2019, the SLP was filed before the Supreme Court. That's the date on the SLP. It's already exhibited as part of the report. The objections, these objections are dated 26 December 2019 and listed first week of January 2020. Jagrati, the petitioner, filed the counter affidavit in the Supreme Court on 16 March 2020. That counter affidavit is on record. And what do they say in this counter affidavit?
On which date?
16 March 2020.
Yes.
Now, what do they say in this counter affidavit? They say the issue before the Supreme Court is whether the civil court has jurisdiction to entertain a challenge to an arbitral award. We have filed petitions before the NCLT. We have filed these objections, which have to be treated as a civil suit. So if these objections are pending, which has to be tried as a civil suit, the Supreme Court need not go into the civil issue of whether the civil court has jurisdiction to, whether the Arbitration Act outs the jurisdiction of a civil court. It is in light of those pleadings that the Supreme Court said we don't need to entertain this particular order of the division bench. You go back to your objections into NCLT and raise all your grounds there.
Okay.
So it is, my objections are not filed pursuant to the liberty granted by the Supreme Court. It is because of the pendency of my objections before this court that the Supreme Court said we won't interfere in the SLP. You go and pursue your objections.
No, Supreme Court, they filed objection stating this fact.
They filed a counter affidavit.
Counter affidavit.
Yes, and the Supreme Court orders of 6th of February 2024.
Correct.
Saying you have filed execution, objections to execution to be tried as a suit.
So before the Supreme Court, before the order of the Supreme Court, you filed the objection?
Yes. Objections were filed on in 2019, listed in first week 2020. Supreme Court orders of 2024, and the entire case was that they've already filed objections which will be treated like a suit. They've already gone to the NCLT. Why are they pursuing this SLP on the issue of jurisdiction being ousted? So this was a wrong or a factually incorrect statement with my learned friend that my objections have been filed pursuant to the order of the Supreme Court.
Yes.
That's factually incorrect. That's contrary to the record. My objections were filed way back in 2019.
When you file this objection here?
The objections are dated 26 December 2019. It was listed in the first week of January 2020.
This objection?
Yes.
When? What is the date? Objection filed before this court on? जागृति इनका मनतोष ऑब्जेक्शन कब फाइल हुआ देखो क्या
It was listed in January 2020.
No, original है
The date of filing the objection. The objections are dated 26th of December 2019. And it was listing was first week of.
That is by way of GA.
Yes.
By way of GA1.
Yes. The GA.
That is GA1.
39 of 2020.
Huh?
GA 39.
Old GA 39 of 2020.
That is objections.
That is the objection.
Yes.
So GA1. So you filed the GA1 on affirm on 26 December.
Yes.
And filed on 6th of January 2020.
And the Supreme Court order is of 2024.
So you mean to say before the Supreme Court decide the matter, pass the order, this Jagriti objection was before the Supreme Court, and prior to that NCLT and this application was filed.
That was the defense. I take the court to the counter affidavit. The court wants me to. I filed the counter affidavit.
Okay.
So the question of Supreme Court deciding anything does not arise. Supreme Court simply says pursue your remedy.
Okay. Yes.
Now, what is the objection on res judicata? Like I mentioned, no cause of action. Now, the court will. I've taken the court to the division bench order. The court, it is very clear in the division bench order that we are not getting into the merits because the civil court has no jurisdiction to enter a challenge to an arbitral award. The jurisdiction of the civil court is ousted. It is in that context the Supreme Court, the division bench said, because the civil court has no jurisdiction, the plaintiff has no jurisdiction, no cause of action to file the suit.
With regard to 34.
With regard to
yes, you have to. You have
the Arbitration Act ousts the jurisdiction of the civil court.
Correct.
And that's the reason there's no cause of action. That's a misreading to say that there's no cause of action to file objections under Order 21 Rule 58 or to challenge it saying it's a product of fraud in collateral proceedings. So merely because the division bench said there's no cause of action to file a suit does not mean there's no cause of action to file the objections. It was in context of that. Now, what is the principle of res judicata? First of all, res judicata does not apply when Supreme Court gives me express liberty pursue your case. But the court may just see the index which I had referred to just now of 25th January 2025. The decisions, Sri Hari only, which I just read.
Yes.
I'll give 5 reasons why res judicata is not applicable to this case. For that, I'll just read only from the index. I'm not taking the court to the judgment. Sri Hari, Proposition 1. To determine whether a suit is barred by res judicata is necessary that the previous suit is decided, that the issued in the subsequent suit were directly and substantially an issue in the former suit. The former suit was between the same parties or parties through which they claimed litigating under the same title. And these issues were adjudicated and finally decided by a court competent to try the subsequent suit. And the decision above that, Shodhan's case, a plain reading of Section 11 of the CPC shows that to constitute a matter of res judicata, the court which decided the former suit must be a court competent to try the subsequent suit. And the suit in which the issue is subsequently raised, and that the matter directly and substantially in issue in the subsequent suit or issue must be the same matter which was directly and substantially in issue in the former suit, and which must have been heard and finally decided by the court in the first suit. It is well settled that in order that matter may be said to be heard and finally decided, the decision in the former suit must have been on merits, where, for example, the former suit is dismissed by the trial court for want of jurisdiction, or on the ground the suit was badly framed, or on the ground of technical mistake, or for want of cause of action, or on the ground it is premature and the dismissal is confirmed in appeal, if any, the decision not being on merits would not be res judicata in the subsequent suit. Now, what are the facts of this case?
So you mean to say that is your jurisdiction?
Both the courts where the first suit is filed and the second suit is filed must be courts having been competent to try those suits.
Correct.
In this case, the division bench has said the civil court has no jurisdiction. We sitting on the civil side don't have the jurisdiction to entertain the suit.
Okay.
Question of application of res judicata does not arise.
Okay.
That's ground number one. Ground number two, I've been non-suited on Order 7 Rule 11 proceedings. On the issue of want of jurisdiction, not on merits. In fact, the division bench on page 71 of that order itself says we cannot address the merits. So I've been suited on, I may take the court to that as part of with the affidavit of opposition, division bench order, page 71, 85, 88.
Yes.
Are the relevant lines where the court has simply said we're not getting into merits. The civil court has no jurisdiction. This is the animal not known to law. And that's the reason no cause of action. So that is what the division bench has said. It is not on merits. And so if it is in disposal for want of jurisdiction, that order cannot operate as res judicata. Now the matters have to be substantially the same. The matter and the issue before the division bench was whether the civil court has a jurisdiction to entertain a challenge to an arbitral award. The issue before this honorable court is whether the arbitral award is a product of fraud. The matters are not the same. That was before the division benches, which is the subject matter of these objections.
Okay. Next.
Fourthly, corporate veil. Division bench itself says that is my money parked in the account of my subsidiary, stolen from there by Jagrati. But since they're not getting into the merits, there is no debate, there's no consideration of the argument. It's not even raised whether to prevent fraud and restore the parties to the original position. The doctrine of corporate veil will have to be invoked to lift the veil to say that the money of Starlight is the money of Starlight and needs to go back to Starlight. That issue was not raised, considered, decided before the division bench. I've raised it here.
Yes.
And those decisions I won't repeat again, which are on invocation of corporate veil. Now, so there are the 4 points. The fifth point is a decision which is in light of Kunya Ahmed's case, that where the Supreme Court has dismissed the SLP in limine. Even the views of the division bench or the findings of division bench on the corporate matters or even this aspect have not assumed finality. It cannot be said that the Supreme Court has the Supreme Court has upheld the views of the division bench because it's an in limine dismissal. Even those issues have not assumed finality, and in fact, in Shodhan's case and Shriyari's case, there's a direct judgment of Asgar on this point that if it's an in limine dismissal, even then the findings of the division bench have not assumed finality. I don't need to go that far because the findings relate to the civil court having jurisdiction to challenge an arbitral award. That's not the issue here. So I don't need to go to that extent. But for the point of completeness, the fifth point is even respect to those findings, it's not res judicata.
Okay.
So what my learned friend has argued that because there's no cause of action, the finding is no cause of action to file the suit, so no cause of action to file this case. When the matters are different, the issues are different, it's irrelevant whether the pleadings are identical.
Correct.
The similarity of pleadings is irrelevant. The question to be considered is what has to be seen.
Okay.
So that is as far as res judicata is concerned. Now, on the last date, my learned friend had brought up the issue of issue estoppel. and given the judgment of Hope Plantation, which actually supports me. The court may see the judgment. I'll just take the court directly to the judgment. Hope Plantation. Whether it's res judicata, whether issue estoppel, these are only rules of procedure. Yet my the entire effort has been to non-suit me out here as well on the ground of citing these kind of judge decisions. Now, the court may be pleased to see Hope Plantation. This was 1999, 5 SCC 590.
The judgment is given.
The judgment my learned friend handed over on the last date.
Judgment.
You have Hope Plantation.
Judgment is given. नीचे रखो क्या?
Okay. It was a loose judgment that was handed over.
1999? Yes, Hope Plantation.
Hope Plantation. Now, my learned friend had read para 29, which is on page 609 of the judgment. But before I read this para 9 to para 29 to show how my learned friend is misreading this para, the court may be pleased to turn to page 608, para 27.
Yes.
608, para 27, as to what is issue estoppel was considered by this court and so and so. And I'll just read the extracted portion. Para 7, in our opinion. In my opinion, the High Court came to the correct conclusion. The basic principle underlying the rule of estoppel is the same issue of fact in law must have been determined in the previous litigation. In this case, it has not.
Decided. Yes.
What has been determined in the previous litigation only is a civil court cannot entertain a challenge to an arbitral award. The issue of estoppel has no application in the first place.
Okay.
Now, then my learned friend read para 29.
Yes.
In Arnold versus National Westminster, the House of Lords noted the distinction between cause of action estoppel and issue estoppel. Cause of action estoppel arises where the cause of action in the later proceedings is identical to the early proceedings, the latter having between the same parties or parties having involved the same subject matter. In this case, it's not applicable. In such a case, the bar is absolute to all points decided unless fraud and collusion is alleged. This part has been overlooked in the argument by learned friend. This is the case where we have alleged fraud and collusion.
Yeah.
Such as justifying setting aside the earlier judgment. The discovery of new factual matter which could not have been found by reasonable diligence for use of earlier proceeding does not, according to the law of England, prevent the latter from being reopened. Issue estoppel may arise when a particular issue forming a necessary ingredient in a cause of action has been litigated and decided. I'll just read this again. Issue estoppel may arise when a particular issue forming a necessary ingredient in a cause of action has been litigated and decided. It is not in this case. And in subsequent proceedings between the same parties involving a different cause of action to which the same issue is relevant, one of the parties seeks to open the issue. However, also barred is complete to re-litigation, but its operation can be thwarted in certain circumstances. And my learned friend read this entire para. I'll just summarize before reading it in my own words. What this authority basically says is, should subsequently, despite due diligence, after due diligence, some new matter comes in, which is relevant to that particular issue, it can be introduced. And in this case, in para 30, the Supreme Court said that exception of new material being introduced is not applicable to India. So that is the exception which is that's where the English law and the Indian law differs. English law, if you have new material, then you can reopen even if there's issue estoppel. In India, if there's no new material, you cannot reopen. That is what the judgment says. This judgment is not authority for the proposition that where there's allegation of fraud or collusion, where the matters are different between the two decisions, even then there will be issue estoppel.
Okay.
So this judgment, on the contrary, supports my case to say, like res judicata, issue estoppel also becomes applicable only when there's a previous decision on the same matter. Now, we have had these arguments on maintainability, on the issue of res judicata, etc. My learned friend has so the first contention was res judicata and issue estoppel, matter of trial, and 5 different reasons why it's not applicable.
Correct.
Now the court may come to see the second point what they raise, what they've said. That is that the provisions of Order 21, Rule 58 proviso are attracted to this case. And so I should be non-suited. First, I was non-suited on the ground of jurisdiction. Now they're saying I should be non-suited because of res judicata and the proviso being applicable.
Yes.
Now, as far as my objections are concerned, they have been filed under Order 21, Rule 58 and Section 151 because it's also force and fraud. If the court may just see for a minute the same index of 20th January 2025. That already. State of UP versus R.K. Pandey.
Yes.
If I may just read, this is very crucial. This is a critical judgment of 2025 itself. If I may just read just 2 paragraphs, paragraph 24 and 25, which is on page 7.
Yes.
We have made these observations in context of Section 47 of the Civil Procedure Code, which even at the stage of execution permits a party to object to a decree both on the grounds of fraud as well as lack of subject matter. And I'll come to this when I talk about the issue of what this is no fraud. It is apparent that the arbitration proceedings were a mere sham and a fraud played by so-and-so by self-appointing nominating arbitrators who pass ex parte invalid awards to retrace so-and-so was not a signatory to appropriate arbitration agreement. More so-and-so parties do not endorse any such agreement. From accumulative facts and reasons illustrated above, this is a clear case of lack of subject matter jurisdiction. And I'll explain how, in our case, what is the position. Accordingly, where law, the present appeal and set aside the 2 ex parte award that is so both awards shall be treated as null and void and non-enforceable in law. And presently, the judgment is judgment is passed, subject matter appeal certificate is set aside, execution proceedings shall stand dismissed. It is where there is an allegation of fraud, and that's also a matter of trial. It is always open to a party, either the judgment debtor or in this case, the third party, that's Order 21, Rule 58, to come in and say, this is a nullity. It is not capable of execution. It's not adding a new ground under Section 34. It's not adding a new ground under Section 34. It's saying there is no award that can be executed. So there's a direct judgment on this point. So my objections are on both Order 21, Rule 58 and 151, and that I can raise at any point collaterally at any stage, regardless of whatever I filed in whichever court. I can always come to the executive court and saying it's a nullity. But I'll now come to Order 21, Rule 58. Now, again, before I get into what my learned friend's objection is as to the proviso, I've already given the case law for the proposition that not only does the objection on the Order 1, Rule 58 has to be tried as a suit, even the proviso to Order 21, Rule 58 is a matter of trial. Opportunity has to be given to the objector to show that there's no delay, or if there's delay, it was not designed or unnecessary, and that the property has not been sold out. That again is not a threshold condition, as my learned friend put it. The case law, which I've already cited, says you have to give an opportunity to the objector. I can take the case to go to the case law. I can just indicate from my the notes
Where is the amount? Amount has been given to or in the court?
Whether
It is
both
deposited in the court.
both. One amount is in the court. The other amount is in the season of the court, because there's the orders passed that you got to retain the identity. That's with Ascot, and I'll also come to the ancillary orders on that. So the money is not gone anywhere. I'll just show that, and I'll show that why from the orders. The court may just see. I'll just the court directly on this first. Before I take the court to the case law, the court may just see. I had given a compilation of the orders passed by this court. Court may see I had given a compilation of all the orders passed. To show how not only has the money not gone, there's no delay.
Yes.
This is the compilation I had given on again 28 January only. A compilation of the orders.
Yes.
I'll come straight to the order of 30th June, which is on page 9.
30th June, 30th July.
30th July, I'm so sorry. My apologies. 30th July on page 9.
Yes.
The relevant part. This is part in the suit. But what my learned friend has said, before I take the go to the orders, what is their argument? Protection was given in the suit. Once the suit is disposed of, protection goes away. And so the money has been sold. That, again, in my respectful submission, is a completely misconceived argument. The relevance of these orders of the suit is that till the time this court in execution proceedings state the execution of the award, not stay of the execution proceedings. This honorable court has stayed the execution of the award and then adjourn the matter sine, and then had filed these objections. Till the date, on the day the stay was granted, the civil court's orders had protected the identity. So the subsequent disposal of the suit is irrelevant. So in that context, I'll just take the court only 3-4 orders to show how that identity has been protected till date. That is the order. The court may be pleased to come to page 12. If I may just read from the third line.
Yes. Yes.
A very serious contention has been laid by Mr. Mitra, learned senior advocate, regarding the execution award. Mr. Mitra was appearing for the objector. In this case, before this court, who was the plaintiff in the suit. To enable this court to consider this application in the presence of parties, I direct continuance of my earlier orders to the receiver with regard to disbursement of funds in his hands. I also direct the beneficiary of the award to retain any funds by it from the receiver in his bank account or accounts. So the first order was direction to the earlier orders. Those earlier orders was put the money in the FDR, in the fixed deposit.
Yes.
So those orders, the money still remains there. The second is, I also direct the beneficiary of the award to retain any funds received by it from the receiver in his bank account or accounts. That identity is preserved within the season of this court. Then the next order the court may be pleased to see is of 12th of August. On the next page itself. This is passed in this execution. Mr. So-and-so, receiver appointed by this court, shall create a short-term fixed deposit of rupees 42 lakhs, etc. with the State Bank of India main branch, Trandor, and shall keep the fixed deposit renewed from time to time until further orders. There are no further orders to do anything with this money. So this remains till date. This money had to be put in the fixed deposit until further orders.
Yes.
There are no further orders varying this.
Yes.
The next order, the court may be pleased to come. I'll take the court directly to the order on page 16. an order passed again in the execution.
Stay.
Stay of execution of the ward, not stay of execution proceedings.
Yes.
This is of 12th May 2015.
Yes.
So as of 12th May 2015, the identity of the funds, 28 crores and that 42 lakhs, have been preserved. This was again until further orders. No further order has been passed.
One factual correction, Malad. These orders of 2015 are all relating to 42 lakh, which is the interest part. Malad, previous orders of 2014, your lordship will see
42 lakhs.
that is regarding these are all 42 lakh interest part. The initial order of attachment, which are of June 2014 onwards, they are in respect of the principal. So that has come and that has been appropriated. So these are all in respect of the subsequent. The interest part, 42 lakhs.
Now, if I may clarify what my learned friend is saying, that's factually incorrect. My learned friend, let me conclude. He'll have it if he likes to say what he wants
These
to
are
say.
the orders of.
That's why I go back to 30th July order. I'll take the code through the order sheet because this is, if my learned friend is going to dispute this.
It's 26 June.
Yes.
The first order.
Yes.
26 June.
Yes.
Series of.
So first, the court will say 26 June is the first order saying 28 lakhs to the receiver, take this money from the account.
Correct.
That's the first.
Correct.
The second orders of 10 July, which says to give over this 28 lakhs to escort.
Okay.
That orders also come.
So further interest payment now.
And the
Receiver will immediately hand over the
28
to escort.
To escort. And then 42 is you also get another 42 from the bank. That
So
is
this 28 is the awarded amount.
This amount
Of
is
the
award
principal.
amount which was directed to be given over to escort.
Correct.
Now, as far as this amount is concerned, on 30th June, 30th July order says I direct escort to retain his identity.
No. First, the 6th June, the 28 lakh 50,000.
Yes.
Correct. Then thereafter, now 10th July, immediately hand over the same to the escort.
Yes.
Interest payable by the judgment debtor to the escort, so and so, 42.
And that will be deposited amount, and that was also to be paid over on 21st July.
So that 42 has come in order dated.
Both have
12th August.
But if I may just complete, this order was passed on 10th of July.
Correct.
On 15th of July, we entered appearance and quantitative fraud is being practiced. That is on page 6.
Yes.
We entered appearance because there were some corrections. None of this had been implemented. There were some corrections. We had immediately entered on 15 July. And that's the, if I may just read this, today, Mr. So-and-so, London Senior Counsel appears claiming to represent 100% shareholder of Judgment Debtor Company, which is disputed by so-and-so, claiming to represent the debtor company. He wants stay of operation to enable his client to make a substantive application. Considering submissions made, I am of the opinion the stay of the operation, if any, can be made only in a formal application. But to enable Mr. Mittal to do so, I direct the receiver to stay his hands by refraining to make over any sum or further sums. This includes both. So this was on 15 July.
Correct. So what has happened on 10th July? So as per the 10th July order, receiver will immediately hand over the sum of rupees 28 lakh 28 crore 51 lakh 83,561 to the escort.
Yes.
This is of 10th July.
10 July.
Then
on 15th, apparently there were some typographical errors in that order. So on 15 July, the matter record says, let the order dated 10 July be corrected in the following manner.
10th July we corrected.
And on the same day, this restrained the receiver from carrying on the earlier directions.
So I direct stay his hand to referring to make any sum.
Any
further sum
That's broad
corrected.
enough.
So now that's why I'm asking, where is that 28 crore now?
Let me take this thing. I'll explain. It is lying with escort. Let me just explain. Let me. I'm told that. Let us just see what the order sheet says. The order sheet says that receiver will hold his hands.
Correct.
Then again we had order on page 8, which receiver will stay his hand for further period of two weeks. 22nd July. Then it appears from the order, because by the time we had gone and filed the suit,
We entered the parents on 15th July, and within the 12 days we had filed the suit. So the suit was taken up on 30th July, which is on page 12.
Yes.
In that suit, the orders have been passed, retaining the identity, saying that if you're given, I direct the beneficiary of the award to retain any funds received by it in his bank account. So if money has gone to Ascot, factually, we don't know. If money is factually gone into account of Ascot, it will retain its identity. So it's still within the season of this court. And as far as receiver is concerned, that there was continuance of the earlier order, and then by the next order on page 13, put it in FDR. Now, learned friend, let me complete, because there's certain things, there's a whole line of trend which I'm trying to argue. My learned friend will have his say.
I'm not on that. I'm not on that. I'm just on that order, factual correction on the order. Let kindly have a look at the 22nd July order.
Yes.
It says, Mr. S.N. Mitra, who was appearing for the objector, clients claim to represent 100% shareholder judgment debtor and have come up before this court with an application which is ready for filing. In those circumstances, because he said it was ready for filing, that application never saw the light of the day. Receiver will stay his hands for a further period of 2 weeks. Until further order, whichever is earlier. Now, my lord, kindly turn to 14th August. 14th August is mentioned for correction. Then, my lord, kindly take 12th August. I stand corrected. 12th August. Kindly take 12th August 2014.
Yes.
Mr. Suresh Prasad Mojumdar, receiver appointed by this court, shall create a short-term fixed deposit of 42 lakh, not 28 crores.
Correct.
With the State Bank main branch, and shall keep the fixed deposit renewed from until further orders. So 28 lakh pursuant to previous orders have been given. No further stay on the 28 crores. This 12th August is restricted to...
That's why, how this 42 lakh has come?
But because if your lordship will see in the previous order, the two different amounts are there. One is 28 crores and the other is 42
That's why
lakh.
the 28 crore is the principal amount.
No, yes, my lord. And my lord, kindly come back to 10 July order. 10 July order, it will become clear. Your lordship will read the two orders. There were two separate amounts. Kindly come to 10 July. First paragraph and the second paragraph of 10 July.
Yes.
28 crore, 51, kindly come to second paragraph. Further interest payable on judgment debtor between 1st May 2014 to such and such is 42 lakh.
Correct.
So there are two amounts. 28
28
crore, 42 lakh.
Correct.
28 crore immediately based on their submission, they're going to file a application. It was stayed. Do not disburse. That order is not continued. So that disbursement happens. But what has been directed to be kept in the fixed deposit is 42 lakh, which is the 14th August order. Of course.
No, Mr.
Let my learned friend not use these adjectives of misleading. I am trying to make submission.
No, Mr.
Please,
Bose.
senior enough not to make
No,
misleading.
Mr. Bose, now kindly come to the 30th July order.
Yes, my lord.
30th July order. I also direct the beneficiary of the award to retain any funds received by it
No,
from
my
the
lord,
receiver.
if your lordship kindly allows me to first take 14th August. 14th August is the continuation. My lord, to 22nd July, Mr. Mitra makes some submissions. So, the previous order where it says do not disburse, that is continued for a further period of 2 weeks. And that do not disbursement applied to both 28 crores and 42 lakhs, both. But then, if your lordship will see the 14th August, I stand corrected, 12th August order, only mentions 42 lakh.
Correct.
Why? Because no application came based on the submission made on 22nd of July. 2 weeks have passed. So the 2 weeks stay.
So that is up till 6th August.
Yes. So by operation of law, the 2 weeks expired.
After the 6th August, the order was not continued.
Yes, not continued. And 12th August, what happens is there is a order on 42 lakh, not on 28 crores.
Correct.
So this 42 lakh order continues, and this 42 lakh amount remains with the learned receiver in a fixed deposit. This is all that I needed to clarify. And your lordship was referring to one more order of just now what fell from your lordship, my lord.
No, that's
Yes. So this
30th July.
yes. So well, this is the position. The initially Malad, the order which was given on 10 July, which was based on the submissions made by them, that they are the 100% shareholder on 15 July was stayed. Receiver not to take any further steps. Then 22nd July, based on the submission made, they are filing an application extended. This 2 weeks extension expired. So 28 lakh.
Continue where I was. I was appearing for the receiver. He had requested me to appear. But two requests he has made. Number one, my lord, he is almost 80 now. And my lord, he wants a discharge and an appointment of a new receiver. Secondly, my lord, this amount of 42 lakhs, the accrued interest, which is there in the State Bank of India, my lord, it's to be matured on the 20th of June 2025. So it has matured already. So, my lord, these are the two things, my lord. And there is some accrued interest which is also there in another account of the State Bank because of an amount which was there in the HSBC Mumbai. The initial deposit which was there, that accrued interest.
What was the amount there?
It was 1,000 rupees then, and thereafter, my lord, it has increased.
So you do one thing, file a report. Tell the receiver to file a report along with them. Then I will consider that. I will accept that report and I will change unless the report is not there because it is a big amount. File a report and this court will find that it is
If your lordship would kindly record that.
I will record.
If I may continue now. There was a point I was trying to make which got suddenly derailed with this intervention. But let me first get the factual matrix correct and then I'll make my point. We get to know from Mauritius about the sufficient proceedings when we get a letter from the bank. That is already on record. We didn't even know what we are not party to any of these things.
I'll just come back.
Oh, I thought you wanted to intervene again.
No.
Very well. I wanted to give you time to intervene.
No.
Anyway, so the court will recall this was the case where I'm not signatory to the war. I'm not signatory to the arbitration agreement. I didn't know about arbitration proceedings. It was procured between the rogue directors of my subsidiary and Jagrati. We get to know from the bank letters when we are in Mauritius that there's a court order saying pay 20 crores in principal amount with interest, which amounted to at that point of time
28 and 42.
28. We enter appearance before this honorable court for the first time on
22nd July.
No, before that, before 22nd July, give me a minute. I'll keep that. On 15 July, we enter appearance.
Yes.
Prior to that, we had already put page 162 is the exhibit A4. That itself is the letter of 7 July sent by HSBC Bank to us in Mauritius, which we received on 10th of July. Within 5 days, 15 July, Mr. Mitra appeared for us in the execution. By that point of time, these orders had already been passed to take 28 crores and 42 crores, 42 lakhs. On 15 July, the language is wide enough to cover both amounts. That receiver stays hands-on restraining to make any sum of other sums collected by him pursuant to the orders of any person for time being. That is on page 6. The very first day he appeared, the blanket protection was given. He was supposed to hold his hand. On 22nd July, when he said we're coming for application, ready for filing, application not in the execution but in the suit. We filed the suit. We didn't file anything in this court. 10 July, we got to know. 15th, we entered appearance. 22nd July, we filed.
Okay, instead of the application, you filed the suit.
We filed the suit.
Correct.
Now, in that and this is within the 2 weeks period.
Correct.
22nd July, we filed the suit on the same day.
Yes.
Within the 2 weeks period, in the suit, the orders passed, which is on page 12.
which talks again of both amounts.
Page
12, which I read.
Yes.
That was the first date when suit was taken up. So it's within the 2 weeks period.
Yes.
Passed by the same learned single judge, Justice Mukherjee, both execution and suit. That was the roster perhaps at that point of time. In the suit, he has passed his orders, the Law Honorable Judge has passed the order saying, as far as 42 is you continue stay your hands to the receiver. That is, the court will see a direct continuance of my earlier order. This is for both. 42
yes.
and
No
28.
problem.
I also direct, this is in addition, direct the beneficiary of what to retain any funds received by it in the bank accounts.
Correct.
After that, as far as 42 is concerned,
then on the same. This interim order will valid 6th August 2024 until further order, whichever is earlier. So this was only 6th August 2024?
Yes.
2014?
Yes.
Correct.
Yes.
Then thereafter 6th August to 12th August, nothing was done. Then on 12th of August,
Yes.
this court has directed the receiver to create a short-term fixed deposit. That was what we is telling 42 lakhs.
42 lakhs. But then there was a stay of the execution, and then subsequently the learned single judge modified the award itself to incorporate this in the modified award. That was I was coming to what
No,
my
that's
learned
correct.
friend.
That's correct. That is, you will come. I will do
Yes,
that.
yes.
But if this order,
Yes.
30th July order is up till 6th August, and
Yes.
30th July August order
Yes.
is to be read with the order dated.
Yes.
Order dated 10th of July.
Yes.
Correct.
Yes.
10th of July is the first order where both the amount has come in picture and directed.
Yes.
Then 30th July there is a stay directing the not to do anything for 6th of August.
Yes.
Till 6th of August till 12th of August nothing was done, and 12th of August only this court has passed an order with regard to the creation of short term of the interest amount.
Yes.
So where is with regard to the where is the principal
No,
amount?
that's how I will continue with the rest of
Yes,
the
yes,
orders.
yes.
Now after that, after 14, we have the order of 31st October. Where there is a further direction, since demurrer application being heard, the interim order passed shall continue till further orders.
Order?
31st October on page 15. After 31st July, 30th July order, we come to 31st October order. The interim order passed shall continue until further orders. The address shall appear. Then after this, there was a stay granted by this honorable court which is on page 16.
So what has happened to this this amount?
If I may just come, let me just complete the order. It will reflect what has happened. After that, as far as the execution is concerned, the matter was adjourned again on page 17. The court may be pleased to then come straight to page 19.
Yes.
Where the learned single judge on 17th August 2015, I'll come to page 21. Last 6 lines from the bottom, in the absence of any challenge to the award, and having regard to the judgment of May 14, I modify the award only to the extent that the respondent number 2 beneficiary, that's the escort, shall retain money subject to any order that may be passed in the execution of the award. This
in
also,
the absence of any challenge to the award, I am having regard to the judgment date. Judgment date 14th May 2014.
I modify the award, so the award itself is modified. I may just point out.
It will retain the money subject to the order that may pass in the execution of the award.
And
yes,
then there's a typographical error on page 22, which has been corrected. And after that, this matter, the objections were adjourned, signed die. There were no further orders passed in execution. the position that emerges is there are two amounts. 42 is clear. In my respectful submission, that 42 itself is also part of the decretal amount. That itself is sufficient to sustain my objections. That by itself is in this court is sufficient to sustain my objections. As far as the 28 crores is concerned, the position which emerges is that there is a positive direction for the directing escort to retain, the beneficiary to retain his identity. The execution of the award itself has been stayed and the proceedings were adjourned signed. All this happened prior to my filing the objections. There's been no revocation of these orders.
So what is the execution? What they have paid for in the
execution is that 20 crores plus interest accrued upon it. So this amount, interest amount is also part of the accrual amount. That itself is sufficient. And the decision which I've cited, which my learned friend has cited also, which is of where they say that you can file order 21 rule 58 is maintainable even if the funds have left the JD.
That is the only here. See, now it is only the receiver who can say where is the 28 crore.
So that is one. That's what they will do. But that is for 28. For 42, we
42 is no problem.
That in my respectful submission is sufficient.
That is no problem.
Now for 28, the court may be pleased to see the judgment of Gopana Subha Raidu, 2009-6 ALD. It is my first, the main volume compilation I'd given. The thick compilation. Case 3.
3.
Case 3.
Gopana Subha Raidu.
Yes.
Yes.
Proposition, page, I can read from the head notes itself. The claim submitted under Order 20 Rule 58 by a third-party decree similar to a suit needs to be examined. That is one proposition. Proposition is Order 21 Rule 58 CPC does not make any difference between movable and immovable properties, even where amount which is not with the judgment that is executed in execution. It is possible for one to invoke that provision. So even assuming it has left the accounts of the Augustus and it has gone into the account of Ascot, I can still sustain Order 21 Rule 58 merely because the check has been given does not non-suit me. Though all this is again a matter of trial. Though since we are on this.
Yes.
The judgments on judgment on case 7 on page 3 and case 8, both are on for the proposition that if there is a fraud, you have to go in for trial, and even if the proviso to be retracted or not, this whole thing about 28 going or not, it's all a question of trial.
Okay.
So my submission is that by the time my proceedings came, and also after this, after file the SLP, the Supreme Court granted a stay of execution proceedings. That's when the matter went out of the list. So when we are coming back to order rule, when there are two aspects of the proviso. One is the property having gone. Second, whether there's any delay. As far as the property is gone or not gone, it's a matter of trial. 42 is very much here, sufficient to sustain. 28, according to us, the identity has been preserved.
Yes.
And after that, the award itself has been modified. The award has been stayed.
Okay.
So the money is here.
Yes.
As far as the second point about delay, these objections were filed, I pointed out the date. These objections were filed when the execution of the award was stayed and the proceedings have been adjourned signed at. So I have learned on 10 July, appeared on 15 or 2014, appeared on 15 July 2014, filed my suit on 22nd July. Throughout, I've been participating. There's no unnecessary delay or design delay. I write till the time the division bench disposes of
your appeal.
Non-suits me, which date is of 6. Division bench is of 3rd December 2019.
Yes.
On 26 December, I filed the objections when the matter is still execution stayed and there's a matter is signed by.
Okay.
So there is no delay. There is, and the matter has very much been preserved. Okay. That is my respectful submission.
on as far as Order 21 Rule 58 is concerned. That aside, I have also filed the objection under Section 151 on the issue of fraud. And most importantly, my learned friend themselves have taken the stand before the learned single judge. They have to file objection, execution. They can't file the suit. That is before the learned single judge. The court will be pleased to see.
What? They have taken a stand?
Yes. The court will see the affidavit in opposition, page 48. They've taken the stand with learned single judge. Let them go in execution. File a community suit.
Directing. Okay.
The court will see that for me. It's very important. How now they're saying the why coming in execution.
Yeah, affidavit opposition to GA1 ka?
This is part of the affidavit in opposition on page 48.
GA1 ka opposition. Page 48.
48. The judgment of the learned single judge starts on page 38 and the relevant part is page 48.
Yes. Determination of question relating to execution.
It is submitted that an award cannot be challenged by a third party.
Yes, take a note.
Yes, take a note of that. They themselves go in execution. Now, when I come in execution, they're saying you can't maintain the execution. Some court has to decide. The civil court says we can't decide. We have no jurisdiction. In objection, I come. They say you're non-suited. They not a sing. My case of fraud has not been decided by a single court from 2014 to 2025.
Yes.
Now, then they have raised this issue of when it comes to Order 21 Rule 58, matter of trial under Section 151 fraud matter of trial. Not only the suit but even the proviso of matter of trial. So this was a defense that they think that there are threshold conditions. They are not. One aspect I wanted to just slip my mind when I was on the first case on the doctrine of merger. I've already talked about doctrine of res judicata. Just before I conclude for today, I think I've run out of time for today. On doctrine of merger, the law I've already given that judgment of the Supreme Court, Punya and Merge, where they talk about discretionary relief, appellate relief. It's not even appellate jurisdiction. It's the discretion of the court whether to admit SSP or not, to grant leave or not. My submission is twofold. According to the Supreme Court, where there is an in limine dismissal, there is no application of doctrine of merger. Because it cannot say we have approved.
It has decided on merit.
Decided that not to, and in this particular case, the reason for deciding not to was pendency of these objections. The second point is, even in the absence of the liberty, I could still maintain these objections. And that is follows from the same judgment where the court says that because if it's the in limine dismissal, it is always open to the person to go back to the forum and say this is a nullity or is fraudulent. I didn't need that liberty. My learned friend is saying that liberty has argued on the liberty itself. I'm saying the holds the liberty. I'm going to maintain my objection. So that judgment I'll take the court to, it will take some time so that I can do that tomorrow. I just listen tomorrow at 11:30 anyways. I can of course continue if the court is inclined to hear me more.
Fixed matter hai kya? Anybody? Koi fixed matter? Then you can continue.
I'll continue. Then in that case, the court will be pleased to the judgment which I'm referring to.
Mr. Shah is waiting for what? Any matter, Mr. Shah?
The item number 44, other side is here. That's why I was waiting. Well, the interim order, my lord, was there. My lord, it has expired. That's why, my lord, we were waiting.
46 and 47.
Well, I'm sorry, item numbers 46 and 47. My mistake.
46? Achha, say. Okay.
Well, that is, my lord, here on my energy matter.
Okay.
If your lordship wants to continue this matter, we'll come back tomorrow. There's no...
Aaj 2 baje kuch hai?
Well, the other side is appearing online.
Come at 2.
Come at 2 o'clock. Very good.
The judgment which I wanted to refer to is Kunai Ahmed versus State of Kerala. 2006 SCC 359. I'm already handed that over.
In which?
So I'm sorry, is it your lordship pleasure to release other matters till recess?
You will continue? How much time will take?
I'll continue till recess. Till 1 o'clock I'll continue.
1 o'clock. Okay. Other matter after recess. Yes.
So this is the
which
this is
judgment?
the
In which
actually it was a loose. I handed over loose copy. This was 2000 volume 6 SCC 359. Kunai Ahmed.
You have given a separate.
This summarized the whole issue of doctrine of merger. And
what is the citation?
2000 volume 6 SCC.
Yes.
And I had on page 371 talked about the two steps. I won't read the entire of it because this is the discretion.
Yes, you mentioned that.
I mentioned that in 2 stages.
Exercise the power under
Yes.
136. 2 steps: granting special leave and hearing of the appeal.
Yes, but the point I wanted to refer to is on 353, where they talk about if it's a dismissal non-speaking order, then you can go back to the High Court, raise the same points again because it's an in limine dismissal. That is, I just want to just mention, just to highlight the para numbers, para number 16, 17.
Yes, I take a note.
These
Indian Oil Corporation.
Yes, and it is that 19 and 21 that I can come back to raise the same point because for the simple reason
Mere
the only
rejection,
reason
yes.
why the Supreme Court dismissed it was not on merits. I can still raise. So my submission is that even dehorse the liberty granted. Suppose it was only specially leave dismissed, no liberty was granted. Even then I could have filed these objections.
Yes, yes. I take a note of.
I've taken that. I won't take more time on this. So first defense was res judicata, second defense was Order 21 Rule 58. Then they said, you've already gone to the NCLT, section 430 of the Companies Act. That I have already pointed out was filed during the pendency of the case with the Honorable District Judge. And it was part of the counter affidavit saying they should go there. And that's what Supreme Court said, one pursue that as well. As well as objection the execution, the court will be pleased to see the order of the Supreme Court talking about both remedies. They're not exclusive. The court says pursue your remedy of objections in the execution as well as any other place you have filed. The court may be pleased to see the counter affidavit for it. They had filed the counter affidavit. It's again loose. I'm so sorry. The loose documents were handed over. The counter affidavit they had filed it before the Supreme Court.
No, Supreme Court.
Yeah, it is.
You're given?
It is. It was a counter affidavit like this. I have one copy again in hand. You have a copy of the counter affidavit? Yeah.
Yes.
Okay. The court may come straight to page 6. This was the counter affidavit filed by Jagriti before the Supreme Court in my SLP. Paper issue with the civil court as a jurisdiction. It was only this short counter affidavit.
Yes, yes.
Not on merits of the case, etc. Page 6, last para. It would not be out of place to mention that the plaintiffs, petitioners have filed application of resisted execution proceedings. In the application, petitioners have disclosed they have initiated proceedings for oppression and mismanagement. Under section 241, 242, 244 Companies Act against the pro forma respondent number 6 hearing and this directed to the NCLT Mumbai, which will be registered as company number so and so. The aforesaid fact of filing of the proceedings on the identical and same cause of action to section 241, 242, and 244 of the Companies Act 2013 against the pro forma respondent number 6 hearing and its active national
National Company Law Tribunal Mumbai bench must before filing the suit has been deliberately suppressed. It was not filed before the suit. It was filed during the pendency of the appeal. In 2017, we had filed it.
Yes.
The oppression and mismanagement proceedings being pending adjudication before forum, no civil suit was maintainable on the same. The Company Act specially bars filing of any civil suit in respect of the matters covered under this Act and does not call for any interference. This was the counter there. We have filed execution and the NCLT matter. Now the court may be pleased to see what the Supreme Court says on this. It's part of the reply itself. I'll just read from the Supreme Court order. Annexure D, page 92. It's part of the affidavit in opposition.
Opposition?
Yes.
Page
92.
Yes.
Heard learned counsel for the parties. I had appeared before the Honorable Supreme Court, and this whole debate was already there that which proceeding to continue. We are not inclined to interfere with the decision of the High Court. We, however, make it clear.
Page
92. Last document of the.
Yes.
This is the order of 6 February 2024.
We are not inclined to interfere with the decision.
We are not inclined to interfere with the decision of the High Court. We, however, make it clear that any other remedy that the petitioners would have invoked, either in the proceedings for the execution of the ward or before any other forum are kept open, all contentions that are available to them in law can be raised and argued. In light of this, how can they even argue that because I've gone to NCLT, this proceeding should be thrown out?
Yes.
Now the court will be pleased to see what has happened before NCLT. The orders I just handed over this morning.
Yes.
Now, may just come first to page 3. That was the order passed on 20th December 2023 itself before the NCLT. Para 3, destroyer of companies. What has happened is this form DR12 requires the signature of existing directors for the ROC can take it on board. The existing directors are the rogue directors, not cooperating. So what the NCLT did was, Destroyer of Company is directed to take on record Form DAIR 12 detailing particulars of the directors and key managerial personnel of the company. This is August judgment letter. To the registrar within 30 days from the date of appointment, cessation changes taking place in designation in view of the non-cooperation of the existing directors in filling up the form of new directors at the ultimate whole annual general meeting. And then the ROC sat on it again. The court will come to the order on page 1 of 10th of March 2025.
Yes.
Para 2. Authorized representative of ROC informs that the request of the council for the newly appointed director shall be considered and needful should be done. Let the same be done within a period of 15 days from today. The erstwhile director and the newly appointed director of the respondent company, as well as the board of directors of Ascot and Jagriti Trade Services Private Limited, are directed to make available all documents, records, information in the control of possession as required by the forensic auditor appointed in terms of the order passed earlier by this bench. Further, all concerned persons should extend full cooperation to such forensic auditors so as to enable such auditor to conclude assignment. In case any of the required documents, records, information claimed not to be in the control of possession, they'll be given affidavit. Then matter was to go on 4th of April. The 4th of April order is on page 5. I just read on IA. The court may be pleased to see. After that, page 6, para 4. Learned counsel appearance for the newly appointed director to place on record one DRA form handed over to ROC for vacant additional record. The same is taken record. However, the petitioner director have uploaded on the DMS portal as well. After that, if I may just come to IA 135 of 2024. I'll just read this para 2 onwards. Record reveals that the matter was listed on the board on 10th March 2025. on which date the erstwhile director and the newly appointed director of the respondent company, as well as board of directors of Ascot Realty and Jagriti Trade Services Private Limited, were directed to make available all the documents, record information in the control of possession as required by the forensic auditor appointed in terms of order passed earlier by the bench. Further, all the concerned persons were directed to extend full cooperation to such forensic auditors so as to make the order conclude the audit assignment. In case any of the required documents, record information is claimed to be not in the control of possession, the person claiming also ought to have filed an affidavit giving the reasons substantiating such claim. However, it is submitted that Jagriti Trade Services Private Limited has wrote a letter under the subject notice of defamation and further legal consequences to Mr. So-and-so, who is the chartered accountant, claiming the amount to the tune of 1 crore for defamation. This is the auditor. Instead of cooperating the auditor, they threaten it. The bench notes that even after directing Jagriti Trade Services Private Limited to make available all the documents, records, information, the control of possession as part of the forensic auditor has not complied with this order, the bench did so and so. Instead, wrote a letter of defamation and further legal consequences in order to intimidate the agency appointed by this bench. Because and what comes out eventually, the last date, the issue was whether we need to refer this matter to the serious fraud investigating office, because the very conduct, I'll take the court through what they've done subsequently. In order to intimidate the agency appointed by the bench to force them to resist and proceeding with assignment, and then they proceed to issue contempt notice against Jagriti. On next page. And that on page 10 and 11 as a show cause notice. Then the matter was taken up on 11th. In between, the earlier orders had been passed on 28th of November 2024 and 28th of November 2024 by NCLT appointing the forensic audit. Ascot went to NCLAT, challenging those orders. No statutory appeal, notice issued, we filed a reply, no stay, nothing granted. In fact, the NCLAT said, we need to know the money trail, where the money gone. Jagriti has challenged these two orders, contempt notice and another order saying that cooperate with the forensic auditor before NCLAT. Again, no statutory appeal, notice issued, no interim stay. After that, on 11th of July, the NCLT has passed this order. This month is only. The applicant Starlight Real Estate so-and-so, these are the objectives for this honorable tribunal report. For the purpose of seeking appropriate orders from this honorable tribunal, India directing investigation terms of Section 213 Companies Act into the field of respondent role Augustus Savani and Welbus Private Limited, and in particular the affairs in relation to its affairs in its joint venture Ascot Realty Private Limited having its so-and-so office. Applicant number 1, a foreign body corporate, entered into a 50-50 joint venture agreement dated so-and-so area with the Indian entity Jagriti Private to form private limited company in the name in India named Ascot Realty Private Limited. Further joint venture agreement dated so-and-so between applicant number 1 and Jagriti was superseded by JV agreement 12 July 2007 entered into between Jagriti, Augustus and Jagriti on the same terms. Fortunately, clause 5.1 of the joint venture agreement provides that Augustus and Jagriti will have equal representation of nominee directors on the board of Ascot. I'll pause there for a minute. As per the joint venture, which is on record, it's part of my objections. 3 directors by Augustus, 3 directors by Jagriti. And the directors, as of date, there are no directors of Augustus on Ascot. So the money is completely under the control of Jagriti. Despite, and the joint venture agreement, I'll take the code to those clauses. The joint venture cannot sue or be sued without the consent of at least one director from either side. You don't give any consent. We have appointed, as a shareholder, we have appointed directors on Augustus who have nominated directors to be on Ascot. So despite Ascot not being a defunct entity and the accounts being frozen by the NCLT, they are still going around filing appeals, entering appearance, and appearing before NCLT, filing appeals before NCLAT. If I may just now read it further. This tribunal appointed Mr. So-and-so to carry out forensic audit and examine the money trail from the bank account statement and record of the respondent company and the Ascot Realty Private Limited by order dated so and so. Admittedly, Ascot Realty Limited has not provided any information so far and has submitted before this tribunal that their appeal against this audit pending before the Honorable Client. Accordingly, the exercise of audit cannot be continued. This bench also directed the director of the respondent company, Ascot Private Limited and Jagriti Trade Services Private Limited, to make available all the documents, records, information, and their control of position as required by the funds reported. However, no documents, records, information has so far been provided by the directors of these companies. It is pertinent to note that the directors on the board of Ascot Realty Private Limited are nominees of Jagriti Trade Services Private Limited in the capacity as joint venture partner in Ascot Realty Private Limited. After striking 424, the provisions of Section 424(2)(b of the Companies Act clearly vest power in this tribunal to require the discovery and production of the document, administration commission for examination of documents. Messrs. Mandelwal Company was appointed by this tribunal to carry out the examination books recorded with Bond Company and Ascot Realty Private Limited. The directors of Ascot Realty Private Limited are nominees of Jagriti Trade Services Private Limited. Accordingly, the directors are presumably acting under the direction and control of Jagriti Trade Services Private Limited. Hence, this tribunal considers appropriate to require the respondent company and Ascot Private Limited to produce the documents, records, information, more particularly bank statements, ledger accounts of related parties, and note explaining the transaction with the related parties in the control opposition as opposed required by the policy auditor of the tribunal. The next date of hearing. Needless to say, the board of directors of Jagriti Trade Service Private Limited shall issue necessary instructions to its nominee directors on the board of Ascot Realty Private Limited for compliance of this order. Right from 2017 till 2025, contempt notice has been issued to the directors who had broke, contempt notice was issued to Jagriti. Till date, not a single report pertaining to Ascot or to the money trail, etc., has been furnished either to the auditor or to the NCLT, which prompted the Honorable NCLT to say the conduct itself shows what are you trying to hide.
Yeah.
Having said that, the proceedings before the NCLT, as reported by the NCLT itself, pertain to operation mismanagement of Augustus, getting rid of the erstwhile directors on Augustus, appointing new directors, getting the information and seeing the money trail. It has got nothing to do whatsoever with whether the arbitral reward obtained exclusively between the erstwhile directors and Jagriti is a product of fraud capable of execution. That's not the scope. I've already cited judgments for the proposition that 430 takes away only the jurisdiction, civil court jurisdiction is taken away only to the extent is vested in the companies. That's a summary proceeding. Serious questions of fraud cannot be gone into by NCLT. It has to, so it's not within the scope of Section 430.
Okay.
So the third defense of what my learned friend was, first res judicator, second was section, the maintainability, order 21 rule 58 and 151. Third was section 430 is there.
That is all.
So let them continue with 430. This should go because we are trying to do parallel proceedings. The scope of both proceedings are separate and independent. So this goes. Now the final contention which they raised, which actually came divided in two parts. One also about the collateral nature of attack, but also what they say, all this is fine, but where's the fraud? According to what my learned friend, when he started his reply, his first line was, the notes will bear out with that. There is a finding by the arbitrator that they were the requirement of putting $5 million. My respectful submission was there is no finding on merits by the arbitrator. So the court, I'll continue this tomorrow, but I just want to summarize this to show what had happened before the arbitrator, how he was misled to travel, not only become to be able to be him. In fact, fraud was practiced upon him also, and how there's neither contractual obligation nor a statutory obligation for the 5 million, and so there's a lack of subject matter jurisdiction, making that award a nullity.
very briefly, because I'm sure it's already almost 1 o'clock.
Yes, it's no problem. Continue.
So I'll just summarize that, then I'll go into that tomorrow more in detail.
Further?
It's matter listed for, it was given 2 days. I'll conclude tomorrow. But also I may point out here, the directors which I have appointed, Starlight, I've appointed Augustus, they have filed already an application under Section 47 in the capacity as JD before this court. My learned friend is appearing for them. We are of course on the same side. They're my directors. Now on Augustus, these are newly elected directors of Augustus, and they filed the objections, which if convenient to the court, may be taken up tomorrow at the same time as 11:30, because marriage is 11:30.
What they find?
Lordship, I'm Sir JD. And leave may be granted to file the GA. The GA is ready to be filed, but not yet been filed. Leave may be granted.
What GA? What you want?
What application I want to file?
For?
The same that this is the problem to what challenging the what, saying that the erstwhile directors of Augustus.
When you receive the notice of the execution?
No. These are, if I may just point out, yes, the orders have the NCLT has appointed the new directors. Now the orders, these are the new directors who have been in the picture now. Are saying that the earlier directors went rogue, they colluded with Jagrati, and we have wanted to challenge after the award being a product of fraud. So the question is not of notice being received with new directors. They've been appointed now pursuant to the orders of the NCLT in March, and the appointment is of June. So this is one of the arguments that my learned friend was saying, which I was coming to when this fraud. Petitioner is not complaining, judgment debtor is not complaining. Who are you to come in? He said, very well, we requested the NCLT, get rid of the earlier directors. We are the majority. We appointed new directors on Augustus. The new directors are saying, even the new directors don't have a single page of the records of Augustus. They are also appearing before NCLT saying, give us information. So the new directors are moving this court by way of substantive objection to Section 47, saying that this award is a product of collusion and fraud. So I'm coming in as the third party. On the only difference between Section 47 and Order 21 Rule 58 is that I'm not party to those proceedings. I'm a third party, but I'm affected. I'm a non-signatory.
That is another thing.
They are the Augustus is directly affected. So they have the locus to file. So the council will be appearing, the council who was for Augustus.
So the execution was against whom?
Augustus. Their final is the JD is Augustus. Money is coming from the Bank of Augustus.
The notice was issued to the Augustus.
Yes. By to the erstwhile directors. But now because fraud has been practiced on the court itself, on the arbitrator, on the court itself, the newly appointed directors, newly appointed by NCLT, now in 2025, they are entitled to come to the court and say that what has happened, that everything being taken for a ride.
So now they are not supporting the award.
They're not supporting the award. They're challenging the award as being a product of fraud. They are my directors. I have appointed new directors on Augustus. Augustus is my subsidiary. I'm Mauritius. They are based in Bombay. Joint venture itself says, I'll take you to joint venture, that Augustus is controlled and owned by Starlight. 100% shareholder. So I have appointed new directors. NCLT has passed those orders which I've read out. Pursuant to those orders, the newly appointed directors are challenging, saying that the erstwhile directors have practiced this fraud.
Okay, let you file them. What the liberty? You file in.
Because matter is anyway tomorrow. I'm here tomorrow for this matter itself. The only request was that
because if it's a new 47, then they have to get an opportunity to file.
I'll conclude tomorrow, so this will be over.
Whether you will accept the notice.
There is no leave required to file an application. Let them file the application. It will come in the usual course.
The department.
Maybe tagged with the main matter.
You first file it. There is nothing on record.
I'll make the request.
Leave is not here in the original side. If you want to file any GA application, you can file the GA application in the department. Master summon will be issued.
Yeah, I'm sure my learned friend will move that application as well. On her behalf, is already moved it.
You file in the department, serve the copy affidavit of service, then we'll see to that. If it is listed, then whatever it is.
I
then
can't prevent somebody.
My only request was
neither
that
the court will restrain you to file, nor the decree holder, awardee holder will restrain you to file.
Let that application be tagged with the main
Okay,
matter.
you file it. You file it, get it number, mention this, then we'll see to
but
that.
I mean, I'm not very familiar with the procedure of Calcutta High Court, but if it can be filed today after lunch,
Ah,
then yeah, I'll mention it.
you file it, get it number, mention it, then we'll see to that. Without the number, how the court can allow you to bring the GA in record? Because there are some other procedure in the department. You go through the
I
department,
think
you file it.
there have been, from what I understand, from the local council we're doing it, but at least for the last 1 month, they had gone to the master, they'd got some notings. Whatever.
So I don't even need to oppose the application. It shows that the collusion is.
Collusion, I'm saying.
I mean, of course, not really collusion, but of course,
My
one and the same.
Because this
He's
whole-
an alter
this whole
ego of
bogey, that's
the
same.
applicant.
This whole bogey of money belonging to Augustus, not to Starlight, etc., all that issue goes away.
Okay.
For the simple reason that now Augustus saying it's my money on my account by fraud.
Okay, let you file in the
Let it
department.
file.
You
Let it
file in the department and
I can only give my learned friend one personal suggestion. Meetings are already on. I was 10 minutes late and it took me 2 hours to get here. I was just 10 minutes late in coming out. So the meeting is right now on. If you want to get out, you get out right now. Otherwise,
you're
it
leaving
will become-
today. When is your flight?
The flight I'm here for tomorrow.
No, you will not be able to reach your hotel. That's what I'm trying to tell you.
Which hotel?
Done without it. So thank you.
Then
so
you
much
can
for
walk.
that.
Then you can walk.
No, no.
Then I'll walk. Thank you so much for that.
Impossible.
But the matter I requested for 2 consecutive days. The court was pleased to put it for today and tomorrow at 11:30. I'm going tomorrow.
Oh, no,
That was
matter.
the reason why we were mentioning this.
Now,
so
with
that
regard to you have to
file it today.
you file it.
And then I'll mention
You file, you mention.
Mention it tomorrow. Mention it tomorrow. Okay. I'll give the
Fix matter আছে হবে এটা fixed আছে just 10 minutes late in coming. That is the right time.
The counsel for the applicant has argued the matter at length in reply to the submission made by the respondent, but due to paucity of time, hearing could not be completed. It is informed that the matter is already fixed tomorrow at 11. Let the matter appear tomorrow at 11:30. Who is appearing for the? He is not here. Mr. Sayathan Bose, learned advocate, appearing for the what is special officer or receiver? Appearing on behalf of the receiver and submit that he got an instruction from the receiver to submit before this court that the receiver is 80 years of age. And is not willing to continue as a receiver and prayed and requested before and prayed before this court to appoint another receiver in place of the earlier receiver, namely. What was the name of the earlier receiver?
Suresh Kumar Sarkar.
Namely.
Well, it is there in the order dated. That July order, my July 2014 order, my lord. Lordship will see first paragraph, the name is there. Suresh Kumar Sarkar. Suresh Kumar Majumdar.
Suresh Prasad Majumdar.
I stand correct. Suresh Kumar Majumdar.
Mr. Suresh Prasad Majumdar.
Suresh Prasad Majumdar.
Considering the submission made by the counsel for the receiver, the receiver is requested to file a report with regard to the present position of the amounts which has been assigned to him within a period of 2 weeks. Let the matter appear tomorrow at 11:30.
Even obliged.
Before when will this night may go away? The evening.
No, it's a yearly thing that
Uh,
on this particular.
Yes.
I am for the defendant. Lordship, we have taken out an application because the plea has been taken that the summon has already been served. Now we have checked, your Lordship, that from the Lordship, the client, the summon has not been served by your Lordship, the directors of the company. And as per Order 29, your Lordship, the summon has to be served, your Lordship, on the directors with the common seal. Now, if your Lordship kindly sees.
My lord, their application is there. I was humbly praying for a direction of affidavits. And today was fixed for cross-examination of witness. My lord, I mentioned the matter in the morning. So that
Today,
the
your Lordship,
witness,
my defense is not on record. Your Lordship, I only request because I have already appeared. Either, your Lordship, my defense will come on the record, or else, your Lordship, I will get an opportunity to cross-examine on the basis of the plaint. But today, your Lordship, kindly sees, your Lordship, once the Code of Civil Procedure Order 29, it has to say, if it is a company, your Lordship, the summons, your Lordship, it has to be served upon the director or a principal officer of the company. Now, the thing is, your Lordship, I'm covered by one of the coordinate bench judgments also. Lordship, I'll take the point because in other suits, your Lordship, I'll get time even after 120 days. But if your Lordship, in this commercial suits, if the summon has not been properly served, your Lordship, I will not get any opportunity to file my defense.
The company is the party?
Is a company is a party, your Lordship.
And directors are not the party?
Not a part, not party.
To whom it was served?
Lordship, one, I think on the last occasion when I appeared, one Moshumi Bhattacharya, that is the Lordship, the service report says one Moshumi Bhattacharya has received.
Correct.
So I have inquired, your Lordship, from my client, your Lordship, none of the Moshumi Bhattacharya is not a employee of the company, your Lordship, holding the common seal of the company. So that's why, your Lordship, I have taken the point that Order 29 has to be served, your Lordship. Summon is required to be served upon the director himself. Otherwise, your Lordship, it won't be considered as a valid service of summons.
If it is the name of the company and the company employee cannot receive the summon.
my lord, and the stamp
So
was put
that's-
in as well.
If it is the employee,
kindly
you
take
show me
on
the
case
section 29.
Order 29.
Yes.
Yes, your Lordship. Kindly take Order 29, Rule 2, Service on Corporation, subject to any statutory. Order 29, Rule 2.
Rule 2, yes.
Yes, your Lordship. Service on corporation, subject to any statutory provisions regulating service of the process where the suit is against a corporation, the summons may be served on the secretary or on any director or other principal officer of the corporation, or by leaving it or sending it to the post addressed to the corporation at the registered office, or if no registered office, then at the place where the corporation carries on the business.
Correct.
So my plea is, your Lordship, the secretary or the director or the principal officer, your Lordship, holding the common seal has to be.
Or not and.
Yes, your Lordship. It's
So if it is
mentioned.
sent, it is received by your employee Mosumi. So the B is covered.
But Mosumi, your Lordship, is not my employee at all.
That is you challenge that. Mosumi is not, then you challenge the service.
I have
you
challenged.
Cannot,
I have challenged the service itself.
so challenge the service.
Lordship,
Then you have to take appropriate steps.
Lordship, I filed an application, your Lordship.
Okay. Mere filing an application will not serve the purpose. You have to examine the process server. To whom it was served, which place it was served. All the things has to be come on record by examination and cross-examination.
Your Lordship, in this
That is the way in the CPC I learned.
No, Lordship.
If you persons are any of the persons challenging the process of service of notice upon the, and it has served through the either postal services or through the bailiff or through the Sarif, then you have to prove your case by examining the witness.
But your Lordship, in
and
this
and here I find that you are making the company as a party. Through whom? That's why the Order 29.
Yes, your
Since beginning, I am telling you all persons are making the party. Suppose Sony Enterprises. Sony Enterprises having its office so and so. Through whom?
Has to be, Lordship, the director or
either director, either proprietor, or either something. You are mentioning in the paragraph 1 and 2 is the through the proprietor, but you are not mentioning. So people, company, they went to the office, served. Anybody XYZ is lying, sitting in the found in the door of the company, they are serving it.
I am not only, your Lordship, is 120 days expired.
Okay, you file affidavit.
I have challenged it.
File affidavit, you examine the witness, then it will become.
I request your lordship in this application itself, it has to be done. Otherwise, your lordship, the
That in
suit-
this also, if
yes,
they will file,
we will
then
file.
up to you. If you want to argue the matter, then the court will. If you want to examine the witness or examine this deciding this issue, because you have taken the plea that the Mosmi is not your employee.
Lordship.
So you have to prove.
Correct, your lordship. If your lordship, they
Neither
file
the court nor the plaintiff will know whether this is the employee or not.
lordship, if let them file an affidavit, if your lordship is convinced that no, I have to prove my case through witness, I will bring my witness. your lordship.
Correct.
Yeah.
Though the matter is fixed today, especially fixed today for witness action, for cross-examination of the plaintiff witness, but the defendant has filed an application being GA Com 1 of 2025. Praying for what you have prayed for?
I've prayed for your lordship this recalling of the order because lordship has fixed the matter as
Prayed for
independent-
recalling of the order wherein this court has fixed the suit as undefendant suit against the defendant. Counsel for the plaintiff prays for time to file affidavit in opposition. Let affidavit in opposition file.
2 weeks, ma'am.
Within 2 weeks. Reply if any
One
there
week.
to be 1 week thereafter. List the matter on 2 weeks, na? On 19th August.
19. Great.
Yes.
I'm grateful. Nancy, please.
Well, the first
side is
item,
there. Other
well,
side
we
is-
have given notice to the other side.
I called both of them.
Well, we have, my learned friend called up both the counsel and the advocate on record.
Shaurujit Ache. Ashika is there.
Well, the intervener is there. Well, the proposed intervener. Well, I'll just remind your lordship, and I think, well, today I don't know to what extent your lordship will take it up.
That's why if the other party is not
Now,
there.
well, I'll just briefly, tell your lordship, I don't want to, press for an order. Well, your lordship has passed an order, in, 857, APCOM 857. Well, against that, my learned friend said they had preferred an appeal. So the matter could not be really taken up. But the interim order in that matter has expired on the 18th. The matter was in the list on the 18th. But because the Piramal matter went on, your lordship could not take up that matter. So that interim order, your lordship will kindly extend. Because that was already subsisting. And my learned friends have said that they prefer an appeal against that. So they have not even
Why you
moved
not
them.
mentioned on that day?
It was our mistake. Piramal went on and
16th को किया तो mention
we had mentioned it on the 16th. Lordship kept it on the 18th.
587 का है?
857.
The order of 16 December 2024.
Where's the order?
But will your lordship kindly permit Mr. Ghosh to appear virtually? But he's waiting in the lobby. But he's asking me to. But there's nobody else in court, my lord, for us. But that is the whole difficulty. Mr. Ghosh is leading me. If your lordship could kindly allow Mr. Ghosh to appear.
GA1, we have nothing to say. So far as GA1 is
Hearing होगा
concerned.
उसी दिन. This is last
Order dated?
Order dated 16 December 2024. Your lordship had thereafter
lastly on June 17th.
on June 17, 2025, your lordship had extended the interim order till 18 July
Order
2025.
कहाँ रखते तुम लोग? 16 दिसंबर को order कहाँ है? Why all order you're not keeping
17
in
June,
file?
is I perceive. This is the parent order. This is the order by which your lordship had granted the injunction.
Restraint for dealing with till 10th of January.
Yes, then your lordship had extended it till the 18th of July.
18th of July. Now we are on 21st.
Yes, my lord, we had mentioned the matter on the 16th. Your lordship listed it on the 18th. But my lord, it was our mistake, my lord. We should have pointed out to your lordship, my lord, that
17 June का order.
17 June is the order of extension.
17 June
Yes, my lord.
till 18 July.
Yes, my lord.
But other side is not here.
My lord, Mr. Dashgupta is there. My
I
lord.
am reading Mr. Dashgupta, my lord. No orders as such is sought for against me. My lord, all I am saying is there is an application for intervention made by my clients. My lord, let it be decided any day your lordship pleases. I cannot possibly stand in the way of the extension of the interim order.
Where is Mr.
But,
Ray?
but the principal respondent is, I do not know whether they are there or not.
Mr. Ray was there in the morning.
আমাদের ডেটা শো কথা হলো অনলাইন
Well, lord, he said he would be there online, but I don't see him.
সনকের সঙ্গে কথা হচ্ছে
Counsel for the petitioner submits that by an order dated 16 December 2024, this court has granted interim order till 10th of January 2025, which was subsequently extended from time to time. And lastly, by an order dated 17 June 2025, this court has extended the interim order till 18th of July 2025. The matter was listed on 18th of July 2025, but inadvertently the counsel for the plaintiff could not mention the matter, and as such the interim order could not be extended. He submits that the respondent had already challenged the interim order dated 16 December 2024 before the appellate court, and the same is pending for adjudication. Considering the above, this court find that the parent order is already under challenge before the appellate court, and by inadvertently the petitioner could not wait for extension of the interim order on 18th of July 2025, and when the petitioner came to realize that they have not made the prayer, accordingly the petitioner has prayed before this court, has made prayer before this court today for extension of the interim order. Considering the above, the interim order is extended till 19th August 2025 or until further order, whichever is available.
Only one more request. My lord, since this matter is pending appeal, my lord, and my learned friends are not proceeding with the matter, if your lordship will kindly segregate the two matters, my lord, keep it in the next monthly list. On the next date, my lord, because I understand my other side is not here, AP number 91 can be taken up.
So let it come on 18th of August.
My lord, 18th August, my lord, I need urgent orders, my lord, in AP 91. That is why, my lord, I was saying that if you lordship...
list the matter on 18th of August 2020.
No, my lord, AP 91, your lordship will kindly keep it at an early date.
Petitioner submitted that the another application being APCOM 91 of 2024 is also pending before this court, and petitioner requires further orders in the said application and prays for fixing the same to some other date. In view of the submission made by the counsel for the petition, let APCOM number 91 of 2024 be listed on today we are on 24th.
24th, yes, ma'am. Very
24th July 2020.
Very grateful.
Grateful, madam.
The petitioner is directed to inform the next date, communicate this order to the counsel for the respondent.
Yes, ma'am.
Yes.
What is the 31? I believe is pass. Sorry, man.
Pasua?
Yes, I'm sorry. In the morning, I was not that 11:30 matter was called on.
Yes. 31, yes.
अरे कोई को भेजो 10 minutes 10 minutes
ये मानने तो कोई को भेजो पेंसिल
no
10 minutes yes
wait for the list to go
31
yes man 31 minute
you are for the
I'm for the plaintiff petitioner
yes
but there are two applications one is
which for the respondent defendant
no it has been served on them written summons has been served on the defendant and defendant never entered appearance service is on record man.
Okay,
we have filed all service reports. Now today, I moved an injunction application, which is my IAGA 1. Disposed of.
What is that application?
Is IAGA 1 is the injunction where Lordship has already...
What is the 2?
2 is judgment upon admission, which is for hearing today, my lord.
Okay.
So obviously there is no opposition filed by them because they have not entered appearance in spite of service. I just tell you, lordship, the receiver has filed a report in GA1. Lordship has appointed a receiver. The receiver, lordship, can see the order, which is 14th of February. I have a money claim against the defendant. Receiver report. And in the
order dated?
Order dated 14th February. If lordship is looking in the receiver's report, this is page 10. Page 10 of the receiver's report.
Page 10
of the receiver's report. Or it can be yes, dispose of করাতে হবে না
10 is the order.
Page 10 is the order. This is an injunction application order. So the receiver has gone there, my lord. And the receiver's report says the lordship has recorded that receiver's report says that it has gone to the page 5 of the receiver's report. It has says that it has gone to the Axis Bank of the respondent. There is no balance in the account. The last 4 lines of this page. The lady went to the Axis Bank and there is no balance.
On perusal of the communication issued.
Yes.
No balance was
No
in
balance.
account number so and so.
So this
Only
goes
one account.
Yes, my lord.
Only one account.
Yes, there's one we could get a hand of. Yes.
Okay.
Next page, my lord, is the office at Crooked Lane. There the receiver went. It was found under lock and key. So he inquired from the neighboring offices that they are not using it for last 2-3 months. From the security in the office also, that it is under lock and key. So this is for the Crooked Lane property. Then the last visit was
Receiver made an inquiry and one of the employee Bharat
the receiver has a security guard of the building. The premise under lock and key for the last 2-3 months, and there's no further knowledge of the same.
Yes.
He inquired from some other companies.
Then what is happening?
Yes.
So what do you want now?
Now today, my lord, I am pressing my application of judgment upon admission because I need the receiver to be discharged. That is the reason I was taking through the lordship to the receiver's application.
Where is the application?
Yes, this is GA2. GA2. The GA1 also has to be disposed of in the same line, my lord. But in GA2, my lord, lordship will see. First is the page 12. I paid him money. He is a manufacturer of cast iron goods. So we used to pay them money for manufacturing those goods. The first MOU between the parties is at page 13, which is of 2004, between the plaintiff Star Pipe and Ashirvad Foundry, who is the defendant. And at page 13, my lord, the rates are mentioned, my lord. The second para recorded.
You are Mr. Star Pipe.
I am Star Pipe. Yes, I am Star Pipe.
Where is the name of the defendant?
Purchaser, then Ashirvad Foundry Private Limited.
Where it is?
In the top, page 13. Top third line. Page 1-3. The page 12 is the MSME, whatever.
This agreement is Star Pipe, so and so, and Ashirvad Foundry.
Yes. So this is Ashirvad.
Yes. Then
the rate fixed 25,000 rupees per metric ton for cast iron manhole covers with frame sizes for required in US and Canada and excise duty. So this is the rate fixed for manufacturing of cast iron manhole covers.
Which paragraph? 2,500, 25,000.
This is the rate. This is the rate that
per metric
ton
cast iron
manhole cover.
Manhole cover.
With frames for all size required for USA and Canada,
yes,
plus excise duty will be charged extra as applicable.
Yes,
26,000.
25,600 is the per metric ton.
Yes, cast iron.
26,100 per metric ton of the
others. Yes, is the different product.
Wall box.
Yes, box.
Then
the rate quoted X works Howrah basis includes apply. But
so these are the two items.
These are the two items.
Correct.
Now this is the first agreement. The second agreement, Lord, you will kindly turn over the page 15. So this is first 2004. The second agreement page identical. Some change in the valuation of 2007.
Okay.
So we continued business.
Okay.
Then, my lord, 2000 page 18 is 2010 MOU. Just the parties were in business, my lord. So page 18 is the MOU of 2010. identical contracts, my lord, with the rates of payment.
Where is the rate in the
Now, in here I'll tell you, my lord, is price of rate. The pig iron price will be the basis of our working out at the rate of rough casting. However, due to day-to-day illustration of the pig iron, rates will be reviewed on every week as and when required, and accordingly a final rate will be worked out. The basis of rate will be pig iron plus conversion plus excise plus VAT. If purchaser supplies pig iron, the rate will be only for the conversion. I am the purchaser.
So
this continued, my lord. Thereafter, my lord, we paid them money, but he could not deliver me the products. Page 21, page 22, rather, my lord, page 21, 22 is the repayment plan that the parties agreed. These may not be important, my lord, because there is a clear document today at page 58.
No. What is the 21, 22?
Oh, yes, sorry, man. Page 21, 22 is the payment and the repayment. Because we paid them money, he failed to.
What is the 21? What the not legible copy?
No, the defendant was suffering with some difficulty, or she will turn over to page 22. It gives a clear. Please confirm the repayment plan as attached. Please note that we will have to stick to it very strictly. Since is involved in this, could you please print on letterhead signed and send back to me so that I can send it to USA. So these are documents. I'm not really banking on this because there's another better document, one which I'm pushing my judgment upon admission. Now, the order 34 is the
34.
Page 30 list of orders, page 37. No, sorry. Page 37 is the list of orders and the challans by which some transactions took place between the parties. Page 38 is the tax invoice. So the transactions were there between the parties. Main document comes in which stops paying at page 40. Page 40 is where my judgment upon admission starts, madam. This is from the plaintiff to the defendant, where I annex a ledger. Page 40.
Laltu Bodak is a plaintiff.
Yes. From at the rate star pipe. Yes. To at the rate star pipe, and this is sent from Ashirvad Foundry. Please find attached. So this star pipe to from Ashirvad Foundry. It comes from from Ashirvad Foundry.
Where it is?
But it is below the FYI from Ashirvad Foundry, and this is now forwarded further. This one. First one is between us.
From the star pipe.
That is between us.
Dated you and between you.
Below that.
And ledger.
Yes, below that.
From Ashirvad.
Yes, this is now forwarded to one of my other.
To you.
Yes.
Okay.
Now, if you turn over to the page, this is page 41, the attachment. This is in the
2324.
Page 41 is the books of Ashirvad. Is my.
This is a ledger.
Yes.
Which you attached in the.
Is what they have sent to us. But she will see the Ashirvad's name is in the top.
Correct.
So, in the books of Ashirvad, my ledger.
Correct.
Yes. So, in the books of Ashirvad, my ledger up to March 2024. It is showing page 42 a closing balance of 47 lakhs and odd.
42?
74 lakhs, sorry.
42 is the 31st of January 2024.
Yes, the closing balance.
Closing balance is?
74, 69, 295.
Correct.
So this is up to 27th of March 2024.
27th of March?
Yes, Lordship will
January.
No. The entry is till January. But she will kindly come back to the page 41 in the top. 1st April 2023 till 27 March 2024. In the top of page 41.
27 March.
Yes. So the ledger is for that period. The entry is till January.
So you mean to say after January there was no transaction?
No transaction, yes. So far this ledger is concerned, there is no transaction.
Okay.
Now this is from them 7469. Thereafter, my lord, the next ledger Lordship will kindly come page 55. Page 55. This, Lordship will see this becomes a reverse. This is in my books, the ledger of Ashirvad. Page 55. But the figure will match at page 56. 7469. This matches with page 42 and 56. Thereafter, the next page, Lordship will kindly turn over. We made a payment of a further payment at page 57. This now I continue till June.
Opening balance 74.
74, and then I made a payment of 10 lakhs. So that makes me brings it to 8469. Now, Lordship, this is up to April. The last payment I made in 9th of April.
Correct.
Now, page 58. This is a document signed by the parties, on which I make my case of a judgment upon admission. This is from the defendant to the directors of the plaintiff. This letter is to explain our current situation, where our foundry has been non-operational since 12th of January 2024. We understand that we owe 8469,294. This is the same figure which I showed you, Lordship. Outstanding to Star Pipes, that was provided to us as against pending work provided in your email dated such and such. Due to internal problem, we had to divert those funds to pay off the high interest burden that we have right now. To reduce interest burden, we have decided to sell our land and pay Axis Bank, yourself and all other creditors. We can assure you that along with this sale of land, we will also repay your entire advance against order in full, as are unable to supply against your order. As we repay back Axis Bank through the sale of this land, we will repay to your outstanding amount in full as well. In the meantime, we plan to repay Star Pipe. Yes. So this is the document. Okay. Now the next document is my demand letter, which remain unanswered. Now, when I moved the injunction application, I found that they said that they will sell the property and pay me off. Now they are selling the property but not paying me. So that is the reason the injunction application was moved.
Where is the document of selling?
Yes, I have annexed some documents of selling, my lord. In the plain tissue, in the injunction application, my lord, I have annexed some documents of selling.
Then
the receiver went to the Howrah property, where is the factory. The receiver records that they have sold a portion in the receiver's report.
Where is it?
Yes. The receiver records that he has sold a portion. Now she will kindly come page 7 of the receiver's report, where he visits the Howrah property at Lilua.
So first is the Axis Bank. There is no amount in the Axis Bank.
There is no Axis Bank in the account amount.
Second is
the Crooked Lane office is closed.
Under lock and
yes,
key.
I run a case that you are selling your factory and not paying me.
And third?
Yes, this is the third one, page 7. Yes. In compliance with the order, the receiver along with the advocate visited the Benares Road, Howrah. The entire factory premises was secured by iron gate bearing the sign board in the name of the defendant. Upon arrival at the premises, it transpired that the said premises was used to operate a casting plant and is left with remains thereof. More fully, iron pillars, trusses, beams and tonneau. Few workers and labourers carrying out civil construction activities were present. It transpired upon inquiry that the factory premises is stretched over approximately 151 katas of land, out of which 8.5 katas of land has been sold to subsequent purchasers. Therefore, said was verified by the few subsequent purchasers who reached the site soon after the visit of the receiver.
So, what is the prayer in the plaint?
Yes, in the plaint. In the plaint,
what is the prayer?
Money claim. I have a money claim. I wanted to protect it because they sell away. Now I have to go to execution for whatever. I cannot ask any further relief. I have a money claim before the court.
Okay, that's all?
Yes, I have a money claim before the court. The plaint is at page 67. Is the money claim of 8469. Whatever the admission figure plus the interest I've charged about.
Is there any agreement with regard to the interest? No agreement.
No, there is no agreement. I have asked for 18%. I leave it on the court. I don't think there is a agreement of interest. Interest upon agreement needs. I just same as this one is the tax invoice. I'll just check whether if it's there at all. No, there's a tax invoice at page 38. Tax invoice does not say anything. No, even the judgment upon admission, that letter also is silent on interest, I must say. No, it is not there, my lord. No, there is no agreed.
Okay.
It is not agreed.
That's all.
But the interim order.
What interim?
I can't say. But the receiver needs to be discharged. The lady receiver needs to be or discharged. Oh, I'm sorry, man. Receiver is discharged. And judgment upon admission, Uttam Singh Duggal, whatever that. Print, taken a print out. Not a narrow.
Paragraph 32.
Yeah, I won't place. Paragraph 12, 13, 14. Paragraph 12, 13. Paragraph 12, 13. Uttam Singh. Paragraph 12, 13, 14.
The plaintiff has filed an application being GACOM 2 of 2025, praying for judgment upon admission. The plaintiff has also filed an application being GACOM 1 of 2024, praying for interim order. Initially, this court has passed an ad interim order, which is continuing till date. Hearing concluded, CAB.
Allah bless.
Yes, next.
34. For the defendant number 2 and 3.
Your Lordships, I am appearing for the plaintiff.
There are two applications. One is a Section 8 application for the arbitration clause, and another is an application for revocation of the clause 12, the Section 12A dispensation, which has been.
Your Lordships, I have all.
And led by Mr. Banerjee, if your Lordship
Your-
takes a day.
Your Lord-
Hearing of this, the Section.
Your
12A.
Lordships, I am appearing for the plaintiff. Your Lordships, I have also filed GA1 for. I am seeking an interim relief. Your Lordships, several occasions, the matter has been adjourned. Your Lordship, they can start with the Section 8 today. Your Lordships.
No, Section 12A needs to be heard first, the dispensation. Your Lordship.
Lord, I appear on behalf of the defendant number 1.
Which is leading.
Lordship.
I can address on both, my lord, GA3 and GA2, my lord, which is the Section 8 and the Section 12A.
I'm led by Mr. Thakkar. Your Lordships, he is appearing.
Yes.
Can you give me?
So you have filed at Section 8.
I have filed two applications. One is Section 8 application, another is an application for revocation of the leave granted under 12A. As I'm praying, because of today's situation, Mr. Banerjee is leading. Mr. Banerjee is requested any date convenient to your Lordship.
My lord, my GA1, which is my application for interim injunction, is held up because of this. One by one, they take out applications, my lord, just to delay the hearing of GA1.
All
Kindly,
these applications were taken out long.
Whether in both the application pleadings complete?
Pleadings are complete.
yes. My lord, both. GA2, GA3, both pleadings complete. GA1, they are yet to file their opposition, supplementary.
Come tomorrow at 2.
Lordship.
Grateful, my lord, deeply obliged, my lord.
May I file the affidavit in reply in GA3?
The defendant has filed two applications being GA1 of GACOM 1 of 2025 and GA2. GA1 and GA2.
GA2 and 3.
2 and 3, my lord.
What is the GA1?
GA1 is their injunction application.
GA1 is my injunction application.
An application being GACOM 1 of 2025, praying for interim order. Defendant has filed two applications being GA3,
GA2 and 3.
GA2 of 2025 and GA3 of 2025. Praying for revocation of Section 12A.
Yes, please, my lord.
Section 12A of the Commercial Code Act, and for referring the parties to the arbitration under Section 8 of the Arbitration Act. It is informed that both the in all the applications pleading have been completed. In view of the above, let the matter appear tomorrow at 2 p.m. for hearing of all applications.
Grateful, my lord. Deeply obliged.
At 35, I appear for the plaintiff, but I was seeking further orders, but today, by view of the resolution, I possibly can't, because the defendant is appearing And today I do not see anyone appearing for the defendant.
Okay, not today.
Not today, my lord. Yes. I'm grateful.
Next.
36. Right, in 36, I appear for the decree holder, my lord. My lord, on the last occasion on 20th June 2025, your lordship had passed an order for appointment of a receiver. My lord, that order was subsequently modified on 26 June 2025, and the receiver was to file a report today, man. And I mean, led by Mr. Subhashish Sengupta, your lordship.
It's not challenged.
It's not challenged because we have got an appeal, but that has not come up for hearing.
It is under challenge, no?
Was under challenge, but my lord, the judgment debtor has not taken any steps.
Not today, nobody's here. Not today, come tomorrow.
I'm grateful.
My lord, appearing for the petitioner, my lord, praying for not today, my lord. Much obliged.
Any matter? Both the parties are ready. No.
Item number 38, my lord. I think
Yes, my lord. I am here in item number 38. My lord,
my lord, in this matter, they have offered, my lord, judgment debtor has offered for the payment of the in 10 installments. My lord, I humbly pray, my lord, let it be 5 installments and let them pay the amount. I do not mind, my lord. If they pay in 5 installments, my lord, because I am suffering from, my lord, I am a small jeweler, my lord, so I am suffering a lot. So if they can pay in 5 installments, my lord, I will be grateful, my lord.
My lord, I'll only indicate, my lord, on the last occasion when this matter was taken up, I had indicated upon instructions that the financial capacity of my client is not sufficient to pay off the dues in 2 or 3 installments. I had indicated that my client wants 10 installments, and your lordship had directed me to affirm an affidavit to that effect. So, my lord, that affidavit is with me, but since nobody could come to court for our side, my lord, it is with us. But I've seen the affidavit. If your lordship could kindly keep it tomorrow, I'll bring the affidavit of undertaking to pay off the entire dues in 10 installments.
Then is every month.
Yes, every month. Every month, on the 15th day of every month, or whichever day, if you, whatever your lordship so directs, I'll pay off the dues, my lord.
My lord, the amount is 32,10,000, my lord, and it will take, my lord, 1 year, my lord, to get, my lord. And this gold
10 months, 10 months.
price is, my lord,
I will
lordship
fix the
knows,
date.
my lord, every day, my lord, gold pricing is rising, my lord.
Fix the date. I will fix the date on payment. Or you come down at 6 or 7.
6 installments, my lord. If they pay in 6 installments, my lord, it will be better.
36 lakhs only, and Senko Jewelers.
Well, this is not the same Senko, my lord. It's the other brother who doesn't have any money. Not the same Senko.
They are using the same name, my lord, in the market, and they have obtained.
You can mortgage one showroom out of 1,000 showrooms.
No, my lord, we only have one, and even according to the decree holder, our gold is fake. It's not genuine. So, my lord, even on the last occasion, that submission was made. So,
No,
my lord,
not fake, my lord. What my submission was, they are not keeping the gold jewelry.
I'll come tomorrow with the affidavit.
Yes.
The affidavit is ready with me.
Not today.
Grateful.
My lord, item number 39, my lord, both parties are here. I think Mr. Banerjee has joined online, my lord.
Yes, your lordship.
Yes, sir, Auric Banerjee, my lord, the affidavit of assets we have received, my lord, in this matter. My lord sees the affidavit of assets.
Yes, your lordship, pursuant to the direction given, I filed the affidavit of assets where I propose that 2 months rent at a time I will pay. Thereafter, the matter was subsequently was not taken up, though we have filed the affidavit within time, and we have also served a copy upon the other side.
We have received a copy, my lord. My lord, if my lord sees the affidavit of assets, my lord, their bank
One second,
accounts have no
Mr.
money.
Agarwal. I have given the details of the assets, whatever is lying within my possession. I have an immovable property. I have annexed the deed. There are certain movable assets inside the saloon, which I have also given the details. And I have also proposed that there is a creditor from which I will get a sum of rupees 8 lakhs. That agreement I have also annexed, where I am saying that we proceed against that creditor and get the money recovered by initiating garnishing proceeding. I am saying that I have proposed that I will pay. Only one thing which has not been mentioned in the affidavit is that there is a security deposit of more than 4,75,000 lying with them till date. let them adjust the sum against my dues in the meantime.
My lord, if I may,
And what I have proposed, I
lord,
will do.
yes. My lord, since we have disclosed the affidavit of assets today, my lord may kindly consider allowing my prayer in the tabular statement, appoint a receiver to take possession of those assets, my lord, and auction those
Receiver
and
get
recover the
possession, then
money,
I
my lord.
won't be able to run the business and pay them off. I can
Bad
only
luck,
pay
my
them
lord,
off
they
if
are
I run
enjoying
the
a
business.
commercial property for 5 years without paying a single penny as rent.
Your Lordship
Is
will
this
kindly
fair, my lord?
take page
And
6,
today a
para
submission
9,
is being made,
page
I won't be
6,
able to
para
run the
9.
business. If you
Without
cannot
running
afford
the
the
business,
place, you
how
should
can I
not
pay?
accommodate it.
Your Lordship, they are interested in getting the payment, the monetary dues recovered. I am
So
proposing that I will pay it off.
the offer which my
One
learned friend is
second,
giving,
Mr.
my lord, will
Agarwal,
take
both
me
of us
5
cannot
years to
speak.
recover the outstandings.
Both of us cannot speak at the same time.
What is the
Let me
amount? What is
extend
the
the
amount you have to
My lord,
pay?
the amount my lord will find from the tabular statement on the date of filing of the execution application, the outstanding was 68 lakhs.
No, that's with interest. That's with interest.
82,750.
That's with
That is
interest.
not with that. I have not even added interest there. This is only the rent which is payable, the outstanding rent. There is no interest component here, sir. If my lord sees the tabular statement, I've given the calculation. My lord has directed last paid admitted rent of 1,09,250. 60 multiplied by 61, my lord. The number of months since December 29 is not paying me a single penny.
66,64,250.
Yes,
Yes,
and
Mr.
the
Banerjee, what is
2
your
lakh,
condition?
Your Lordship, my contention is
2
that
lakhs 18,000 I
one
have added,
second,
my
one
lord,
second,
for
one second.
Mr. Agarwal, just a minute. Yes.
One second, Your Lordship. My contention was that first of all, Your Lordship will see the first of all on the merits of the execution case. If Your Lordship sees the prayers from Roman 1 to Roman 4, all the reliefs which have been prayed for in the execution application is in the nature of final relief in the suit, wherein they are seeking eviction against my client and mean profit. So they are entitled to mean profit if they at all are successful in the suit.
That might not be only with regard to the what this court has passed an order with
Correct,
regard.
correct. So with regard to that, I have proposed that if the receiver is appointed over the property, I am running a salon. This is very small businessman, sole proprietor running a small salon. So if the receiver is appointed, the shop is taken possession of, then I won't be able to pay. I'm interested in paying. I have proposed in my affidavit that 2 months rent at a time I will pay. Kindly take my affidavit, page 6, para 9. I have said that I will clear the dues without prejudice to my rights and contention. I state that I will like to pay 2 months lease rent at a time from 10 July 2025 onwards. Now, Lordship, since the matter was not taken up, so that's why we could not propose this fact before the court. And Your Lordship, without any specific order, we could not have. That's why. But we are interested in paying the dues at the Your Lordship, 1,09,000 is the lease rental per month. So if it is calculated, it's 2,18,000 per month.
Banerjee, if it goes 66,000, 66 lakhs, 64,000. If it go 1 lakh, then it will go 64
5
months.
years, my
No,
lord. It
2
will take
lakhs at a
5
time.
years to recover the
2 lakhs at a
outstanding.
time.
That is his
2 lakhs at a
proposal.
time, Your Lordship. We have also proposed that for a
2
security
lakhs,
lending.
1 lakh is the current, my lord.
Mr. Agarwal, I'm here.
Mr. Agarwal, this is
That's the present monthly rent.
Your Lordship. I have said that I will pay off the money at the rate of 2 months rent at a time, and in the meantime, let there be an injunction over the property. They can take the title deed as a security. I have annexed everything in my affidavit. It's not that I'm shying away. I want to pay it off. And in the meantime, their monetary dues can be secured by an injunction over the title deed. They can keep the original title deed in their custody.
My lord, may kindly
So
look
the
at
money
para
is also
5
been
of their
secured.
affidavit. My lord, my learned friend is saying that he will pay 2,18,000 rupees. My lord, may kindly have para 5 of their affidavit. Para 5 at page 3. My lord, in their 4 bank accounts, the total money available is 1,300 rupees. 1,300 rupees, my lord. The first bank account is 526 rupees. The second bank account is 21 paisa. The third bank account has 471. My lord, page 3. Page 3 of their affidavit of assets.
Okay, then you examine the judgment.
Lordship, so wherever I will pay, that
Yes,
is
my
why I
lord.
am saying that whatever is coming
But
as a
in the
business,
interregnum,
whatever
my lord,
revenue is being generated, I will pay the money from that account.
But
Whatever money is generated from the
Examine the
business,
judgment debtor, you examine the judgment
Yes.
debtor.
I will pay money from the I will pay
Yes.
pay money from that account.
Yes.
If you want the total decrease to be executed, then you have to
My lord.
examine. And he is not ready to
Yes.
pay the amount.
No,
Yes,
Lordship, I am ready to pay. I
Ready
have,
to pay 66 a month, it cannot be allowed, sir.
Your Lordship, my financial capacity does not
Current
permit
monthly
me
rent, and
any
you have
further
taken
payment apart from
1 lakh. So
And my
examine
lord,
the.
and my lord, in the interregnum, some, my lord, whatever assets they have disclosed, at least that
Sir,
should have.
either you take the money or you proceed the matter. If you want to
No,
take
no,
the money, you accept the 2 months rent. I am
no,
disposing
no,
of this.
then we'll
If you want the
examine.
total decree,
Yes.
then you examine the witness.
We'll examine. We'll
If the
examine.
judgment decree or judgment debtor is not able to pay the amount.
I am not able to pay. I am proposing that this is the amount which I will be able to pay. I have also proposed
examine
that
the
there is
witness
a
and see how the amount is to be recovered.
immovable property is there. Let them take the original possession of the title deed. The money decree is also secured then.
Affidavit of assets, wherein the judgment debtor has stated that without prejudice to his rights and contention, the judgment debtor will pay 2 months lease rent at a time from 10th of July 2025 to the plaintiff till the realization of the total decretal amount. This court find that the total decretal amount is 66 lakhs
64,250 plus interest.
64,250. The decree holder also paid for interest for an amount of rupees 2,18,500. Full stop. The decree holder is not ready to accept the proposal given by the judgment debtor. Let the matter appear. Give the date for examination of the judgment debtor. 26th of August at 3 p.m.
Grateful.
Judgment debtor.
Great.
Yes. Yes, any both the parties are ready. Matter or otherwise.
43 item number. I am appearing for the decree holder. I intend to move, subject to your lordship, my lord. I want to move the injunction, my lord, because the judgment was passed for a sum of rupees 25
Then I have to call the serious. Call the matter. Not today. 42. Not today.
43, I am for the decree holder, my lord.
You're for the 43?
43, my lord.
Yes. Give the 43.
Judgment is, my lord, at page 473 of my affidavit in support of the tabular statement, my lord.
Where is the judgment?
Judgment dated 12th of August 2014, my lord. Relevant portion is, my lord, at page 75. Page 75, my lord.
The plaintiff in the suit succeed. The plaintiff is entitled to principal amount of rupees 25 lakhs.
Yes, my lord.
Interest
Plus interest and a cost of rupees 50,000, my lord.
18% per annum on itna from the date of issue of the check, 3rd November for realization. Termination and cost 50 lakhs, 50,000. Yes, then.
Yes, my lord. My lord, kindly come to page 10 once. The property of the judgment debtor which we have gathered from sources, my lord, at page 10 of my affidavit, my lord.
Yes.
This is the property details which we have gathered from the searches, my lord.
What is the date of the judgment?
Date of 2014, my lord.
14.
2012 August 2014, my lord.
Notice, issue notice without the
No,
notice.
I've seen, my lord, I've seen notice, but it was written with the remark left.
Where is that? Where is the affidavit?
My lord, it is with me. I'm sorry, my lord. Kindly, today I can't reach, my lord.
2014 order.
2014, my lord. I have seen recently, my lord. It was written with remark left. Both the addresses.
Correct.
Both the addresses, my lord.
Okay. Give the affidavit. Where is the affidavit of service?
My lord, it is with me, my lord. Kindly pardon me, my lord. I could not reach, my lord, today. So kindly keep it tomorrow, my lord, or any day, your lordship convenience.
Yes, next. Not today. 45.
My lord, I am appearing on behalf of the decree holder. I am led by Mr.
May it please your lordship.
My lord, I am appearing in item 45 on behalf of my lord, the petitioner in the execution petition. My lord, I apologize for some medical urgency. I could not come physically to court.
Yes.
My lord, may I only indicate in the matter I'm being led by Mr. Rotnanko Banerjee, is my senior in the matter. My lord, there's an extreme urgency, but I understand Mr. Banerjee is in some difficulty. I'm only praying if the matter, my lord, may be taken up tomorrow, but I'll indicate the urgency also, my lord. My lord, kindly take up. Well, this is a decree. There's a decree in our favor. Your lordship will kindly take up page 125 of volume 1. I'll only take 2 minutes, my lord. Page 125 of volume 1, my lord.
Yes.
That's the terms of settlement, my lord, by which the matter was decreed in our favor. It's an admiralty suit. Your lordship will kindly take up page 130, Roman 7. Page 130, my lord, Roman 7. Your lordship will find it's indicated plaintiff's entire claim in the instant admiralty suit shall stand satisfied, settled, and fulfilled. Upon complete satisfactory receipt of the sums in the bank account, plaintiff shall have no cause of action surviving against the defendants or her owners, captains, crews, operator, manager, or any other person or company related, nor will, not over the page, nor will the plaintiff file any other claim or take any preservation measures against sister ships. My lord, kindly see the next clause, Roman 8. Likewise, the owners of the defendant number 1 vessel or her charterers, captain and crew, operators, agents, it includes everyone, my lord, or any party interested in the vessel shall not have any claim or cause of action or grievance. Now, the difficulty is, my lord, now these parties, my lord, when they sign this, my lord, this terms of settlement, which is Roman 8 at page 131, they are now initiating an international arbitration in London. And my lord, tomorrow is the last date for us to, my lord, nominate our arbitrator. My lord, if we don't, my lord, there is a possibility that they are going to proceed against us in an arbitration. My lord, if we do, then my lord, our execution, our decree goes for a toss. My lord, either way, we'll suffer. So my lord, that's the urgency. But Mr.
How the arbitration? Against which the arbitration is started?
My lord, they are, my lord, the main owners now are, my lord, initiating an arbitration or have initiated an arbitration against, my lord, the charter party. My lord, now the difficulty is this party is initiating a proceeding against us in London. That's an arbitration that they are going to, my lord, seeking to invoke, and they have sought for nomination from us. The difficulty is, my lord, we cannot nominate because they can't proceed in this manner. Then, my lord, this decree becomes otious. So, my lord, that is the reason, my lord, the execution and where, my lord, we're going to argue that there has to be, my lord, an anti-arbitration injunction in our favor. But we'll argue that there are judgments in our favor which will show. But I'm only praying if this matter can have some precedence tomorrow, my lord. Since I'm led by Mr. Banerjee, my lord, I'll beseech your lordship.
Not today, not
my lord, may I only have some precedence tomorrow, my lord. Otherwise, if this matters,
is there, Mr. Bag?
My lord, may I only pray for this, my lord? If it can be taken up.
You lost the chance today, then come tomorrow at the serially.
My lord, may it retain its position. The only difficulty, my lord.
That is the problem of the bar. When you get the chance, you will not argue, and you will argue, praying for fixing a specific date. When the case has come on the list, you persons who are busy in the other matters. So what can be done? Yes, next.
My lord, may only beseech once, my lord. I'll not trouble your lordship thereafter.
No, sir. No, sir.
Not only this matter, but since there's a
you lost
since
your
Mr.
chance
Banerjee is
today,
leading
what can be done? You could have been ready today.
My lord, I'm ready to argue, my lord, because I have a leader, my lord. I'm held back. That is the only reason, my lord. I'm ready to argue, my lord.
Come with the leader tomorrow. Yes, next.
I'm deeply obliged, my lord.
Your Lordship, I appear for the plaintiff in item number 48. Your Lordship, I'm praying for not today.
Okay, no. एक काम करो, फाइल का साथ उनको भेज दो.
Lordship, item 9, it is a suit which is ready for hearing. On 10th of June, your Lordship has fixed it for hearing on 7th of July when your Lordship perhaps was
Hearing
not sitting.
of
The suit is ready for
argument.
Final arguments. So I'm only praying if a date can be fixed because today defendants are also not there. Only a date can fix.
Undefended suit?
No, it's not undefended, but this is that suit. If your lordship will recall, Mr. Huda was appearing for the defendants when the defendants refused to come to the examination before just Mr. Charan Gupta, and he went to Mumbai saying that he has an injury when he didn't wanted to come to the commission. So your lordship has closed it and it's ready for arguments. So any date convenient to your lordship.
Right. Tomorrow 3 p.m.
Lordship.
My lord,
Record an order 49. 49, huh? Let the matter appear tomorrow at 3 p.m. as a specific matter.
But item number 51, but item number 51, my lord, I appear for the plaintiff. This is an undefended suit. My lord, Mr. Haq was appearing for the defendant, and Mr. Thakkar leading Mr. Haq was making his submissions. If your lordship could kindly keep this matter on any day, my lord, subject to your lordship's convenience for final arguments in the suit.
It's final argument. Come tomorrow if time permit. It will take.
My lord, yes, my lord, we can come tomorrow.
It will be listed. It will be on record list only.
My lord, item number 57 is undefended suit. I am for the plaintiff, my lord. May I file my affidavit of documents and judge's brief of documents?
Witness is present.
Witness could not come today, my lord. I was praying.
Come on that day. Along with
date
the
should be fixed when he will be present in court.
When will be present?
Any day your lordship directs.
कब होगा कोई डेट है? 2nd September you will find the date. If you or you want to take the chance, then it let the matter remain in the list.
I will take this.
My lord, item 54, my lord, is an undefended suit. My lord, here the defendant has never appeared. It's been set undefended for a while, my lord. My lord, it's ready for final argument. Only one correction needs to be carried out in the deposition. If my lord will kindly have that. The deposition, may I hand up a copy of it? Question numbers 13 and thereafter, my lord, relating to exhibit C. My lord, the witness has answered 70 to 83, but it has gone down as 72 to 83, making it will be 70. Yeah, only that much. If that can be carried on, my lord, we'll argue the matter, or we'll bring our notes and arguments and finish it.
Return number?
54, my lord.
54. Counsel for the plaintiff submit that. The matter is on 17th April 2024. The plaintiff witness number 1, namely Shyam Sundar Mantri, was examined as PW1, and during his examination in question number 16,
Thereafter.
16,
Look,
he has identified the documents appearing at page 70 to 83. 70 to 83 of the judge's brief of document. Judge's brief of document?
Judge's brief of document.
Judge's brief of document, and the same was marked as exhibit C collectively. But in the deposition at question number 16, the pages has been wrongly recorded as 72 to 83 instead of 70 to 83. In view of the above, in question number 16.
13 also, my lord. Same thing has happened in 13 also.
16.
Pencil.
In question number 13 and question number 16. ऊपर में जितना भी होगा दोनों ही है. Question number 13 and question number 16. Question number 13 and question number 16. The page number shall be read as 70 to 83 instead of 72 to 83.
Obliged. Deeply obliged.
This order.
But my lordship will not take up the matter fixed at 3 p.m., my lord.
Ready, I will take, no problem.
I was appearing for the
ready, I am.
But an application has been filed by the defendant. This is an undefended.
3 p.m. में कौन सा matter है?
I am appearing for the defendant.
Commercial list 9.
Yes, my lord. Item number 9.
Yes.
I am appearing for the defendant, my lord. I have preferred 2 applications, my lord. Now, one has, my lord, come up in my lord's list today, that is GA-COM 2. And another application is for recalling of the order dated 30th April.
What is the GA2?
GA2 is delay condonation, your lordship. But
delay condonation
of the recalling application, which is, my lord, pending in the before the learned master, your lordship. And master summons.
What recalling? What order we want to recall?
My lord, 30th April 2025. Your lordship.
What is the order?
Your lordship had closed my right to defense Your Lordship. But Your Lordship, I have gathered information from the concerned department and from the learned register original side that my written statement was filed before the learned master within 120 days, Your Lordship. And on the day that GA1 was for acceptance of the written statement. Now, Your Lordship, when GA1 was taken up, Your Lordship, the learned advocate on record, my lord, he's also present here, my lord, his brother-in-law was suffering from tuberculosis.
Twice the matter was called, I remember.
Yes, Your Lordship, that matter, Your Lordship. He could not appear.
I remember each and every order which I passed.
Your Lordship. Your Lordship.
You not appeared on that day.
Your Lordship.
First day you not appeared, second day not appeared, then the court has passed an order.
Your Lordship, I have tried to explain, Your Lordship. I'll try to satisfy Your Lordship on that ground, Your Lordship. But
no, you taken leave, but after filing of the application, you flee away from the court. You not appeared in the court on twice or thrice. What the court will do? Court Somoto cannot call the report from the department and accept your written statement.
My lord.
Then,
my lord,
yes, what is your contention?
Serious medical.
But I thought that no written statement has been filed, because that is in the application for acceptance to file written statement. Nothing was, no statement was made. Whether written statement was ready, where
They not appeared. They filed the application, but they not appeared.
And Lordship is absolutely correct. Lordship remembers it quite vividly. It was called twice or thrice. So, we'll argue whenever his application, the other application comes up in the list, we'll argue that, my lord. And if it is found the written statement was on record, then perhaps I will not have anything much to say. But let that report come.
When your matter will be listed, when your application will be listed.
My lord, learned master, Your Lordship has not given any date for taking out of the master summons, because the law.
Rectification has been made.
My lord, all rectification has been made, Your Lordship. Only, my lord, the master
Item
taking out the
number
master
9.
summon is pending.
Though the matter is fixed today for witness action at 3 p.m., but the learned counsel for the defendant submitted. Defendant has filed 2 interlocutory application, being GA 2 of 2025 and GA, and 3, GA3,
Your Lordship.
GA3, 2025, for condoning the delay for filing an application for recalling of the order, and one application for recalling of the order wherein this court has not extended the time for filing written statement. Counsel for the plaintiff submit that, and defendant submit that. The defendant has filed the written statement before the outer period of 120 days, but the same was not brought to the notice of this court, and as such this court has dismissed the said application. In view of the above, let GA1, GA2 and GA3 of 2025 be placed before this court on 4th of August 2025. The department is also directed to submit the report whether the defendant had filed a written statement. Defendant has submitted any written statement before 120 days with the leave of this court or not. Let the report be filed on the date fix.
Let a copy of GA3 be served on us. GA2 has been served. GA3 has not been served.
Or the defendant is directed to serve the copy of the application, being GA3 or GA2.
GA2 has been served, but GA3, what my learned friend was talking about, has not been served.
Along with the document to the learned advocate for the plaintiff by tomorrow.
Your Lordship.
Lordship, item number 53. My lord, item number 53. I am appearing on behalf of the plaintiff.
Yes.
My lord, this is an undefended suit. My lord, Mr. Rajoshi Dotto is leading me. He's waiting in the lobby. He has not been given access yet by my lord's court officers. My lord, if my lord kindly recalls, my leader was making arguments in the matter because it's an undefended suit. Now, my lord, in the course of arguments, one query fell from my lord as to how the demurrage claim was being established by the plaintiff. My lord possibly recalls USD 24,000 my lord had called upon. Now, my lord, we have taken instructions from the client. There are, my lord, 2 or 3 additional documents which perhaps may satisfy my lord's query. Now, the difficulty is, my lord, we will have to, since this is a commercial suit, take out an application and seeking press. My lord, Mr. Dotto is here with my lord's.
My lord remembers this undefended lordship had posed a query. We have now, my lord, inquired from the my lord plaintiff. They could, my lord, give us some documents, but we have to take some steps. So we were only praying, my lord, if 3 weeks time is granted, we would take that step so that, my lord, we can eventually come back.
54.
53, my lord.
Learned counsel appearing for the plaintiff submitted, though the matter is fixed for argument, but the plaintiff intends to bring some additional document on record. Accordingly, he prays for time for taking appropriate steps. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 20th August 2025.
Lord, before your lordship rises, Lord, item number 57 was mentioned by my advocate on record, that undefended suit. And your lordship had given a choice to take chance or fix it on 2nd of September, my lord. My advocate on record said we'll take a chance. So your lordship has not fixed the any date, and it has just been made not today. But just that difficulty, my lord, tomorrow I will not be there. My witness is ready, my lord. So if it could be taken up day after tomorrow, my lord.
Mention tomorrow, I will adjourn, no problem.
Very well. I'll ensure my advocate on record is there.
That's all.
May I mention one matter, Your Lordship? GA1 of 2025 in CS 13 of 2025.
Not listed.
No, Your Lordship. It was kept as part heard in Your Lordship's list. His Lordship, Arinda Mukherjee has the determination, Your Lordship. The matter cannot go there as the matter has not been released formally.
Which matter?
Jay Surana versus the Calcutta Swimming Club.
Calcutta Swimming.
Yes, Your
Yes.
Lordship.
On the last occasion, I told you that
Lordship, a formal order is required.
No, because that is parted with regard to that order has been passed.
Today, the matter was mentioned before His Lordship. He said the formal order with regard to release of the matter is required. Otherwise, he cannot take it up.
What release?
If it can be kept tomorrow as to be mentioned or. এটা লাস্ট অর্ডার ছিল, এটাতে পার্ট হার্ড করা হয়েছিল।
Listing है क्या? List है? The matter is listed and the matter is mentioned by the learned advocate for the petitioner.
Yes, Your Lordship.
Petitioner, and submits that by an order dated 26th of February 2025, this court has fixed the matter as part heard, and as such, and subsequently the determination is changed and prays for release the matter from the list of this court. This court find that by an order dated 26th of February 2025, this court by an order dated 26th of February 2025 fixed the matter as part heard, but subsequently considered the final order work. But subsequently on 20th March 2025, 20th March 2025, this court has already passed an order by rejecting the interim prayer of the plaintiff, and as such, no question, and as such, the part heard, and as such, the matter is released from the list of this court.